that, give it
we just don't count.
and you'll get, you might get one of the patio stones and you make it okay.
Well, unfortunately,
Okay. I bought a Sea-Ray last year. A 22-year-old came with a trailer, and it's down at Calvin King's, getting a new motor.
So
So
see, I'm the only one. They said 8 o'clock, yeah, they said 8 o'clock last night.
Okay, the 235, yeah. That's a tough one. I've got a few of those guys that are really good to be in the off season.
Well, that's all right.
Yeah, okay, so the landlocked thing, behind his house is a huge shop. I mean, he has to spend close to $1 million on this shop. So that's not what he has. 3 century machines, 2 girls that work on them.
Well, good morning, everyone. It's 9 o'clock. Are there any declarations of pecuniary interest this morning? None. Resolution moved by Councillor Douglas, seconded by Councillor Wayenko. Be it resolved that Committee of the Whole adopts the agenda of July 12, 2016 meeting as amended or circulated. Suggestions for amendment? Seeing none, we will read as circulated. All those in favor? And that carries. First item of business is the community leaders meeting follow-up. Summary?
Thank you, Worship. I took really good notes at the meeting, and we hadn't really talked about how we would move the items forward, but I didn't want to let it sit, because I think the community members spent a lot of time telling us what issues they had, so I put together my recollection of what happened at the meeting. I had Bob Duncanson go through it to make sure that his recollection and mine were the same, so we were on the same page. And then I put together some suggestions on what we could action, what we couldn't, how we might action. So I would suggest that probably the most efficient way is probably to go through sort of each of the items highlighted and look at what I proposed for the township response and give me some direction on whether that's where you want to go or you see things different.
Councillor Edwards?
Just a question, how do we get the people who were at the meeting engaged with what you witnessed?
Through the chair, we can share the report, we can share any changes to the action. As I said, Bob read it, and I understand he did a similar report with his group, and they fairly mirrored in the facts of what happened that day, where it differed was what the township response would be. So when council decides what the township response will be, I can go back through Bob and let him know, and we can let him through. But there's some different things, some places where we want committee, some places we want some education. Bob also read the responses, and he had some comments that I adopted where I could, and did do where I could.
Supplementary here. I just want to ensure that the people who were there are still engaged in what we decide on, what we're commenting on. Because otherwise we're sort of talking to ourselves, whereas what you're really hoping is they can be satisfied and agree with the comments.
Yeah, absolutely. Well, I can circle back with Bob once Cal gives us some direction on if what we're proposing works, or if you want to suggestions on each item that they talked about what we can do, and we're looking for some direction. I'm talking to myself.
Well, which one do you want to talk about first?
Oh, we can go on. The first one was planning. So they had some thoughts of what they liked or would like to see, and definitely it was around education and enforcement. So we're suggesting the Director of Development Services does some more education. I think he's got a series of educational tools in mind to do some letters in the news each month about something different. The department's working on some pamphlets, some educational pamphlets. They are going to offer out that they'll do educational sessions in the college associations, and the first one may be coming up very soon. So that's our plan on education. On enforcement, that was a much trickier one for us. We really only do enforcement on a complaint basis. And unless council wants to look at a different model of staffing, there was talk in the meeting about boats up and down and different things that we just don't have the capacity to do. I think we talked a little bit more about being engaged with the college association. They can let us know what they're seeing.
Let's do one at a time.
Let's do one at a time. Okay. So education. So we proposed monthly newsletters, education sessions on request, and brochures about our process.
Yeah, I think our first educational session is coming up on the 23rd of July with the 6 Mile group, so that could be a format for other college associations if they wish. I think 3 of us will be there, Councilor Kruger and Councilor Wojcik will be there, so maybe they can take a look at it and find out if they can farm that up to associations probably later on this year or next year, so that's something that maybe we can keep that in mind. And I'm sure we tailor each one, if a particular association does have a character plan, that would be obviously an add-on to the program, but there should be a generic discussion on planning issues and how they're handled and so on through the committee of adjustments and all that.
I agree with the whole thing that those sessions would be helpful, but I think for some of the college associations, that probably, we don't have, because we don't have a plan, it's probably would be more effective, specifically for some of us that are speaking of some of the Lake offices, I know that's, where through these newsletters, forms that we can recirculate by email. I think it's very important that people have the dogs we need at the time, so.
The education sessions are on request. We won't waste ourselves on you if you don't wish for us, but it's an option that's available to associations if they wish them, and do the other pieces through the meeting, for sure.
Edwards?
I think it's sort of auxiliary to what was suggested yesterday. The big issue is size of cottages. So I think what was being suggested as far as looking at that is probably one of the items that's at the top of the list. And whether it's large cottages or a combination of large cottages and small lots, I think that's probably where we have as many hot points as anywhere. And it seems to be throughout the township is just related to one area. And so I think we need to get that. I don't know where that was being left, Larry. I mean, was that being added to the agenda for next?
It's coming in September. A report from planning.
Okay.
Councilor Wojcik?
Yeah, well, I think it's a great opportunity to interact with the different associations. I think we should have an end game to this, though, with planning, to try and get everybody on the same page as far as the planning department goes. So that moving into the next term, which I believe we're going to be looking at a new official plan, to have all the associations on the same page, or it's the term after that?
New official
Or
plan,
the-
5 years after the one we're working on
Right.
is enacted, which might be next year.
Okay, so just to get them all on the same page, I think Nick is going to be.
Yeah.
I think Nick's going to be faced with a challenge with these community plans, that by the time the next one rolls around, we may end up with 10 different community plans. So that, we already have 2 or 3, maybe we try to get everybody on the same page to sort of like cross over from one area to another, so that what goes on in Cog Machine maybe can be similar to what happens on 6 Mile, and similar to what happens in other areas. The ultimate goal is to have one official plan and not have a whole bunch of community plans.
Yes, Lori, and this is gonna take all day if we spend this much time on each bullet.
Yeah, I just, in response to Councilor, when we put together the initial plan, that was not the direction that we took, and that's not what we heard from the year's group either. I agree for simplicity for us, it would be definitely easier to have one plan, but council committed at the time, and I believe are still committed to community plans. So I think maybe in the minority on that one. And I think the great goal is to get everybody on the same page, but I'm not sure that that's a possibility in this township. We'll do our best through education and engagement and communication. If we could get to one page, we have done a really, really good job. I don't know the chair of my planning committee over there who went through the old community zoning bylaw and said,
Hell hasn't fallen over yet.
not possible.
Okay, our first bullet, education, is everybody comfortable with what's proposed there? Okay, so how do we want to do this on the resolution?
So my resolution, your worship, says the committee recommends to council direct staff to undertake the steps outlined in the report. So if you agree with what I've proposed, then that's the resolution.
Well, we may not agree with all of it.
Right, and in
So-
which case I've left you some blank. Saying you agree with everything except for on item X, you'd like us to do something different. With a,
Just to sort of move through this, I wonder if we could identify a couple of things that we'd like to see somewhat different, or maybe at another session. I have a couple of areas that I'd be willing to comment on, but I don't need to go through line by line. Might help expedite this a little bit.
sure, bring that to you, my worship, just to point out, have a discussion on the things you don't agree with. If you agree with the majority, then tell us the things that you like.
That's sort of where it's going, I guess.
Okay, we'll start with you then.
Okay, let's see. So it's not that I don't agree, it's just that on the enforcement side of things, I think we need to have a more fulsome discussion as to whether we need to have a different format for staff, et cetera, to have a greater deal of enforcement, or a greater amount of enforcement. And so I'd like to see that matter discussed in more detail, perhaps in the August session of the committee as a whole. I personally would like to see more enforcement, and maybe there's a way to look at it so that we can be a little bit more proactive out into the communities and where there's been problems developing. So that's my first point. I'd like to see something on that. Second thing is that relates to very much further down. We can talk forever about taxation, but I won't. Just in terms of voter engagement and voters list, I'd like to see some more discussion around that matter as well. I think that based on some of the comments that I heard from the leaders, I think there's some misunderstandings around voters lists and voter engagement and responsibilities of voters to get their names on the voter list, etc. So I'd like to have a more fulsome discussion around that. So those would be the two high points for me on this report.
Lori?
If council agrees, that's absolutely fine. Just back on the enforcement one, Councilor Cooper into August, we could do it October maybe, because we're in the middle of high season, and we're probably not going to accomplish too much different this summer, but if we start the discussion later in the fall to look at, A, coincide with budget process, and B, look at our plans for the following summer. If you're not in a great rush, if council wants to discuss that in greater detail.
So
Some other nodding.
That's fine with me. Supplemental vote to that, I would just suggest that maybe what we can do is from an engagement perspective is, I'd be happy on the voters list issue to do a little bit of groundwork with some of the leaders and just get their thoughts so that we have something prepared for when we can have this discussion at Cal, whether it's in October or something like that, that's fine. Those are my two.
Our item C, is that including anything on the voters list today? No. Okay.
No, I don't want.
So as far as the enforcement issue, I would suggest that discussion be surrounded by budget, because it's obviously going to involve dollars.
Okay. So more specific, September, October.
Voters list, if we want to delegate that task to Councillor Cooper to bring some more information.
So up to council, what I suggested is, and this went back, I think, to the last election, there was some talk about engaging a committee, and when I was speaking to Bob Benjamin, who was keen on that, and that's one thing that I did change for, at his request. I had said, the election is a while coming, let's start it next summer. He said, I think we really should start talking about it this summer, so I proposed asking him to get a working group together. Open to suggestions, that's what Paul said.
I'm just trying to get it happening.
Yeah, so he came back and said, can we do something this summer, just to talk about clearing up the misconceptions, and then talk about what our plan is for the following year.
So why don't we task Councillor Cooper to work with Mr. Duncanson to get a working group together, and then bring a report to committee of the whole. Sure. That's okay.
Before that's even started, wouldn't it be a good idea to get a list of what people qualify to vote? Because, like, I don't know, if husband and wife own the property, that's fine, they both get to vote. But what if they have kids that are 21 years old? Are they allowed to vote?
Kids have to be on the deed or live here or be tenants.
Yeah, so we should have that. People are going to
That's in the election act.
I know, but there should be a form. What about cottages that are in trust?
Yep, we have an education package that, before the election comes, the clerk department normally goes out to all the associations and all that. We can refresh the group on that certainly, but most of that work has already been done. And just is available.
Okay, you're finished with your points?
Yeah, and
Everything else was okay?
everything's fine, and I'm also very excited that Jessica's going to have something else to do.
I'm so excited too.
Okay.
Leaving.
Who had their hand up first?
Well, we should probably just go across the whole thing. Everybody should have said.
Yeah, okay, you go ahead. I'll just go around the circle.
Okay, I think I'm on line with some of this stuff, but I think we need to talk about service levels when it comes to enforcement. And I think sometime in September we should talk about service levels, because if we're going to do enforcement, that's going to require another body. So I think we need to talk about that. That's going to be a budget item. The other budget item on service level review is increased septic inspections. We had talked about an additional team that could be available, either one person or two people that could be available for another year, so we can get this 7-year turnaround on inspections for all our systems. So I think we need to talk about those two service levels, so septic inspections and enforcement. On the voters list, yes, I agree, there should be a committee chaired by maybe Bob Duncanson or whatever, but we should also keep in mind a lot of the concerns that come from the Bay, but we also have to keep in mind that the inland lakes also have voter list concerns, so we should make that comprehensive and so on. So any small group put together should be a group geographically representing all the areas within the township. The other issue with grants, I think we need to have a discussion on what grants that we do want to have in the township. I think we're talking later about a grant for some of the school children and so on. So I think we have to have a fulsome discussion on grants. And I think at that meeting, the group indicated that, yeah, there maybe should be more grants available for possibly other things, or maybe more for recreation. I don't know. But I think we need to have a discussion on the extent of grants that we're willing to put aside each year. And the last one I had was communications, and there was an indication of how we communicate. And I'm always indicated that I think most of our associations have communication people associated with their associations, and I think these people should be brought together to find out how willing they are to spread the word. Because I know most of these associations have email addresses for the majority of their people. If we get to these individual cog association communication officers, we may be able to get our information out a lot easier through emails and so on. So I think we should harness those individuals in the community, in the associations, and get our information a little easier.
I really don't have a lot to add to that. I mean, with Councilor Concern, Councilor White, I've covered most of the things that I was wanting to, but just in regards to the communication aspect, one thing that I would caution you on is that some of the associations will not, right? So, I mean, it is a discussion that should come up and we should be having it, and also in regards to the enforcement aspect, just some questions have been raised on a number of different occasions as to whether or not people need to put their names to the complaints, because that is one of the reasons we don't get some of the complaints. They don't want to put their names to it. So just a couple of things maybe to add. What council's regard to it.
I think Peter's covered off just about everything that I was wanting to talk about. The only thing is to do with enforcement. I think we've tasked our CBO to the end. You know, being in district court, being out doing inspections, trying to enforce things. I think we really need to review and look at staffing in the building department and try and offer some help there. It could even be that we train somebody in enforcement that will be in the septic team, so when they're out doing septic inspections, at that time they can look at infractions into the enforcement area. But I think that's something we really need to look at hard. The majority of complaints that I'm getting at the AGMs is, yes, planning is doing a great job, but when we run into things that are wrong, there's nobody there to really drop the hammer on these people. And we need a real education process on what we can do. Because I don't think we're doing the maximum of what we can do, and people think it's a joke and they just walk away and do what they want. So I think we really need to look at that part. And that's it. Everything else looks great.
I'll just continue on with the enforcement one, just because it's raised most recently. I have a little bit of a concern because I've raised a couple of issues and I've been told, oh, give us the name or give us the address. I think we have, and that gets more difficult. I think what really needs to happen is for staff to say, okay, let's go look at the map and you point out which property it is. Because for me to know the name, the person, or the address is much more difficult. So, and I have a concern that not having the name or not having the address is being used as a way of minimizing the numbers. So I would just be suggesting that staff go to the next level, which is, here's our map, point to which property it is. So that's my 2 cents worth on enforcement. My issue, and I was planning on bringing it up at another session, is with regard to the Honey Harbor waterfront plan. I do not agree with what has been written. I went and met with Mr. Lamb of Parks Canada, and I will bring those we do need to do something for Honey Harbor, but this, in my view, just doesn't do it. And that's why I was raising my comment with regard to what other places are doing with regard to refugees or whatever. I think we've got to think outside the box a little bit more. Back to my comment on, wouldn't it be nice if we could get a group going that we're building aluminum boats in Honey Harbor, et cetera. So I'm going to be bringing that one back as far as bringing it to Cal with the comments of Mr. Lamb and my comments after talking to a number of other parties. My other concern, and the lights went on slowly, unfortunately, on this one, I think we have to be very, very careful when senior levels of government give us money to do things, because I think, unfortunately, there's a tendency to look at it and say, well, this is great, we're going to have to put up 10% of the money, but we have all the legacy costs. So all of a sudden, not only do you have the operating costs of whatever the money's been given for, but you've got all the replacement costs, and that can be a big number. I mean, if we looked at, the Honey Harbor plan, $5 million, so we only put in $500,000, but we've got stuck with the replacement on $5 million, and I think we really have to think those things through. So those are my 2 cents.
Any comment on Honey Harbor waterfront plan? Council's already made their decision on it. And we know Councilor Edwards' position on that.
Yes. What my township response for council consideration was on that even when we get funding, then the council can have another discussion on the project, but I don't have the resources at the moment to put into that, and that's probably not the right time. That's really all I commented on it.
So that's a wait and see if funding comes.
But Larry, my point is something has to be done for Honey Harbor. So I don't think we can just say, oh, well, we didn't get the funding, therefore nothing's going to get done for Honey Harbor. And there are a number of other issues.
We'll have that discussion.
And I will bring it and put it on the Cal agenda. We haven't, as far as I'm concerned, we haven't fully exhausted the decision with regard to what needs to be done, or what could be done.
Councilor Kay?
I think everything's covered.
So your worship, would you like me to just recap what I've heard? Make sure we're all on the
I
same
think
page.
we've probably gone around the table enough.
Sorry.
Most of the items are budget. Brian brought up what I understand is cross-training in bylaw in regards to enforcement, that sort of thing. So we do have a number of bylaw people that are bylawed to be bylaw officers, and they're the building inspectors and such. So you go ahead with your recap.
Okay, so if I go page by page, I heard under education that we're going to do the first pilot education sessions from Cottage Association on the 23rd, and we're going to get some feedback from the members in attendance at the time about what works and what didn't and what we could do differently, and then we will make that available on request. And then I heard on enforcement of bylaws, we would like to have a more open discussion on that, and to bring something back in the late fall, because it will tie into a budget discussion, and then we should look at service levels, staffing, cross-training, also reviewing septic inspections, probably as part of that same, it's a different discussion, but a similar one. That anonymity is an issue, and address is an issue. If I could just address the addressing issue, when Councilor Edwards were asking for an address, because we don't always know, right, we don't know the amounts as well as you do, so typically we get those complaints in an email, but if you want to come in and point to it on the map for Nick, I'm sure that can help, but we're not so good at the brown cottage on the end of the tip of the island, that doesn't give us a lot of direction here in the office. Also during budget time, we need to have a fuller discussion on our grant policy. We have a recreation grant policy right now, so perhaps it's not meeting all of the needs. You want a bigger one? And we should reach out to the communications people in the college association to see if they are willing to distribute our information. And Councilor Cooper is going to work with Mr. Duncanson to get the working group started for voter engagement, and it needs to have geographical representation.
Okay, so how do I word my resolution? That's a lot of writing right now. Or do we refer to your notes and put them in the minutes?
Staff direction is in the minutes. If the first part of the resolution gets passed, we can say as regarding staff direction.
I think, Your Worship, because the community leaders are so engaged with us, we probably owe them an appropriate resolution back. So if you want to move to your 9:30 training, I will draft something while that's going on, and you can come back and have
Okay.
it done.
Okay. So, we have John Daly here. Welcome. And thank you very much for coming up here. And I understand this is out of the goodness of your heart that you're going to train us.
You ready, Richard?
No, actually, I will take the latest one.
Very much, if I may have just a quick minute to introduce John. So John and I have worked together off and on over the years, and he's currently the clerk at the county of Simcoe. But last month we passed a policy on FOI, and we had a few requests recently on emails, FOIs, councilor emails. So John's had some very recent experience on that, so I thought he would be a great speaker for you to do the training that you asked for. And it came out of the goodness of his heart because he owes me a favor too.
Don't worry about it. We already may owe you one when we're through here.
Yes, one day. We'll be even after this. So,
Well, this was a good trade. The favor was they get to name my next born, or I deliver training for her, so turn around.
I already have 3 kids, so it wasn't willing to have any more.
Good morning, Your Worship and members. It's a pleasure to come up this morning to Township Georgian Bay. It's a great break from the city of Barrie. Deliver something that I'm actually quite passionate about. I've done MSF for a process, MSF in one way or another for probably nearly 20 years. You can feel sorry for me later. It is something that municipalities, the province of Ontario, and even the federal government live under some form of privacy legislation. And in fact, there's approximately 5 different pieces of privacy legislation. Municipalities, for the most part, are subject, voter tier municipalities are mostly subject to one, and that's MSF. PHIPA may also come in play if you have a health board that is a tight relationship with you. And in fact, if you operate ferry services, provincial legislation, privacy legislation also comes into play. So it is a very complex field to be in, and I'll touch on that briefly. Anne Cooper was the privacy commissioner for the province of Ontario, and had tight oversight for municipalities and amending MPIPA and amending the provincial legislation, PIPA. And this is her statement. I'm not a big fan of reading to you unless you'd like me to read the statement to you. Actually, sorry, Jessica, was the slide deck provided to members of council? Do they have it on their screen?
No, I just received it.
Okay, it's right here. Okay. So one of the most important rights of citizens in a free and democratic society is access to information about government activities. Without a written record of how key government decisions are made, transparency is undermined and the basis of its policy choices may be shielded from public scrutiny. This is a very powerful paragraph. Later in the slide deck, you'll see where I address under the Municipal Act the role of municipal councils. And I'd like you to reflect back on Ann's paragraph. So what I've done here is I've highlighted, without a written record, transparency is undermined. In modern day municipalities, I got my first computer on my desk about 1989, and that's when the scourge of big municipalities or municipalities overall started, and it's called email. And email is one of the largest unstructured repositories of information. And what I mean by that is you go into your file room, and everyone was fantastic with printing that memo, signing that memo, copying that memo, putting it into a file folder. That all was obliterated when email was introduced, because it's not common practice for us to print that email, walk into the file room, put it into that file folder. Our email boxes continue to grow larger and larger and larger. So, but without a written record, transparency is undermined. That means that in my email box, I'm the only one that has possession of it. It's not in the file folder that everyone else in the corporation has access to that corporate knowledge, that awareness. So this is, again, very powerful. I'd like to take ownership of that paragraph and remember it as we go through the slide deck. So obviously, the legislation itself provides that every person has the right of access. Every person. It goes on about, and we'll talk more about this, about custody control in the institution. And I think that's an important area that this council has an interest in, is what about custody control. And we certainly will talk about the Oshawa case, but also another case in the city of Toronto. I believe I've provided a couple of handouts. The city of Toronto had a police officer that was using his personal Hotmail account to conduct, I don't want to call it citizen engagement, but he was engaging during the investigation using his Hotmail account. So the IPC has already come out with an order against or to advise municipal staff, in this scenario with a police officer, that he in fact has to turn over his personal email account so they can conduct direct reports. In Oshawa, the IPC came out and now guided elected officials to say your Hotmail account should be provided to stop. So the municipal staff were already subject to in their Hotmail accounts. So again, the right of access extends itself beyond your elected officials and into the staff realm, and also obviously into institutions. This is very important. Most municipalities, the act is administered through the clerk's office. I believe that's the case here. It's in the case of all municipalities that I've worked. It's all administered through the clerk's office. They're designated the head, and tongue-in-cheek, I've put what's called the subject matter expert. Right? If we live it, we breathe it, we become the subject matter experts who apply the act as deemed appropriate. This slide right here is all the amendments that the IPC has issued. And to get my other glasses, that says June 15th, and that's May 23rd. So it's not very often that you'll hear the province of Ontario say, since May to June, we've amended the Municipal Act, we've amended the Elections Act, we've amended the Government Act. It takes years to make amendments to legislation. But in fact, every time the IPC issue a new order, such as Oshawa, it changes how the clerk applies the Municipal Freedom of Information Act. So clerks become the subject matter experts because we are reading all these orders that come out from the IPC that change how we need to apply what we believe is a static piece of legislation. It is not static at all. If you take a look at the time in which all these are issued, as of last night at 8 p.m., I am likely no longer the subject matter expert because the IPC have issued a new order, which has changed how I'll be applying the legislation. So, looking at the legislation on face value doesn't get you all the way. You need to take a look at the orders. So, elected office. You were elected by your peers to represent them, to be open, to be transparent. But the funny thing about elected offices, it's not defined in the act. Right? I'm going to suggest that given the Oshawa circumstance, given the national defense appeal to the Supreme Court, tapping into elected offices, tapping into hotmails or personal accounts is new territory for oversight bodies, being the IPC. So this is new, and I'll tell you about in Springwater, my former municipality. They were either second or third on the list of the IPC asking for access to hotmail accounts of elected officials. Springwater is currently in the adjudication stage, meaning the parties could not, the elected officials, there's two elected officials, if I remember my file correctly, that opted not to provide access to their hotmail account. The other 5 did. So that had to go to adjudication. When adjudication happens, they'll issue an order. And the order is binding on the municipality, binding on the elected official, and we'll talk later about offenses. It's in fact an offense of $5,000 to not follow an order of the IPC. They're at adjudication. Aurora is the second municipality, or second or third municipality, and they're also, I believe, in the adjudication stage. So having an access request for access to your hotmail accounts is not new. Started in Oshawa, it carried on into Springwater, it carried on into Aurora, and as of last month, County Simcoe, we also have a new access request for access to hotmail accounts. Sir?
Can we ask questions for long?
I'm completely aware of that.
When you say you need access to personal email accounts, how far into the computer do you go? Do you go into your sent box? Do you go into your delete box? Do you go into your archive? You know, like even on the hard drive, you know, how far into the computer do you go to provide?
That's an excellent question. Let's eliminate computers and then ask the same question. I'd like access from January to December of 2015 information. How far do I go? Well, I'm going into Lori's office. I'm going into Brad's office. I'm going into Jessica's office. That would be the inbox, the sent box, the deleted folder. So the answer to your question is yes, you go where the information resides.
But if I was, if everything was hard copy, my delete would be the garbage can, and the garbage can would be gone by now. So the only thing I would have in my office is the inbox material. That would be what I put in the file. And all my delete, it goes in the garbage. So,
yeah, absolutely. My Outlook is designed that when I exit, it deletes everything in my delete folder.
yeah.
I'm bound by the municipal act, our retention schedule, that says information shall be kept current +1, current +7, whatever the case is. I have a legal obligation to decide that that email is in fact a record, to print it or to save it into a file folder or online somewhere. By deleting that record, you make a conscious decision that it's, I shouldn't have called it a record, by deleting that email, you make a conscious decision that that is not a record and you're allowing it to be deleted. Or if it is a record, you made a conscious decision not to follow a bylaw of the corporation. Again, go back, I'll just reflect back when we did not not have computers. If you receive a piece of correspondence from the province of Ontario and you shred it, is that a record of the corporation? I suggest to you it is. By shredding it, you make the decision to contravene your bylaw by shredding that piece of information. Just because it's an email does not change the fact that it's a record and it needs to be managed. Sir?
I find it very interesting. I mean, obviously, we've seen the issues on the national front, Mr. McGinty and his computer, Hillary Clinton, et cetera. Is the answer simply use the phone and do not send emails? I mean, that's what I'm taking from all of this.
Anne would be shocked if I were to suggest to you that you don't want it to be read on the 6 o'clock news, and don't put it in writing. The fact is, it's a record of the corporation, it should be in writing. You know, if you're on the phone with someone and they are exchanging information which the municipality needs to act or make a decision, you in fact should be putting pen on paper or in fact sending an email to say, I've received information that the municipality must act on. I heard you talking about the septic bed reinspection, right? You know, Mr. Jones calls and says, it's clear that the septic bed has failed, it's leaking into Georgian Bay, I need an enforcement to happen. And you in fact make the notes and my favorite record.
I can see that this is going to be a great growth industry, but I'm cutting through to the practical, which is, it is probably best if we limit what we put in emails and use the phone more. Am I missing something on this? I mean, surely I'm not going to get into trouble because I use the phone more.
I'm just going to suggest that regardless of the medium which you use, if you are materially advancing the business of the municipality, whether it's on a phone, on an email, or on a paper record, it is a record of the corporation and it should be managed and accessible, because that supports accountability and that supports transparency. So I'm a big fan of the phone. I told you early on we have a scourge on us, and it's called email. I encourage all of my staff, for which there's approximately 35, to pick up the phone, to shadow my doorstep first. I'd like to see them in my office before they pick up the phone. Pick up the phone second. If they can't pick up the phone and you absolutely must send me an email, fine, go ahead and send me an email. But I'd rather see you in person, phone, and email. Either way, regardless if they come to my office, regardless of the medium, if they are reporting a health and safety infringement, I in fact want to document that issue because it's a corporate record. It needs to be managed and it will be used in a court of law or in proceedings that materially advance the business of the municipality. So phone, email, paper, whatever the case is, if you're materially advancing, document it.
Brian and Paul.
Just for clarity purposes, because this really interests me a lot, because I'm involved in it. IPC, I know it as the Investment Planning Council. Can you tell me what your IPC is?
Yeah, I do apologize, clerks or anyone for using acronyms. The Information Privacy Commissioner.
Information privacy.
Paul?
A couple of things. I have no problem sharing my emails, business emails with staff. The concern I have is with individuals out there who have inquiries. And they, can get my email and then use them against me. So that's what my concern is with. I have no problem sharing emails on a business process with other people in business who are good. It's when they get out for the bad. And that's what I have. So that's one issue. The other issue is if I wanted to avoid having to hand over my personal emails, can you set up a company? And I'm only an officer of that company. And therefore, as an officer of that company, I can communicate with my constituents through that company. But they would not be not part of the request of an institution, so on. Is that happening?
I can't speak to whether or not that's happening. I'm going to suggest to you it doesn't matter. If you are communicating about the business of a municipal corporation, then that is a municipal corporate record. The municipal corporation, and by extension to the ITC, they're not asking for your business records, right? If you're, building boats or septic tanks, no interest in that. What it is if you are acting on behalf of the municipality and it's in your abccompany.com email account, then that belongs here, and it needs to be managed and it should be accessible. You mentioned one thing about the constituents. Constituency records are off the table. They belong to you. If you're communicating, I'll get to this, I have a slide here. If you're communicating with a constituent and you're advising them about you can access municipal services, or the name of the CAO is Lori Kennard, those are constituency records.
Yeah.
Right? The IBC is solid that a constituency record is exempt from the Act. But you have to keep in mind the fine line, and I'm going to talk about the fine line a bit later. Constituency records versus a corporate record. Right? The business, sincerely advancing the business, or are you enlightening the constituent about municipal services? So again, institution, that's the municipality, that's Georgian Bay. So this is the question, is it possible to be accountable without providing access? I won't read these two paragraphs to you. The answer is yes. So records relating to your institution, the township business that are created, sent or received through instant message tools, like I said, we've been focusing on email, but text messages, I'm not a big fan of the whole Facebook and Instagram and all that type of thing. If it's about municipal business, that's subject to the Act. Receiving messaging tools, personal email accounts are subject to the access provisions of HIPAA. And then we have Order 2836 that's saying just because we have it doesn't mean we're going to give it. The Act is about providing access, and the Act is about applying privacy provisions. And when I say privacy, it goes beyond what you might think of my personal information. It may in fact cover off financial obligations. So in an earlier municipality, the councillor gave me a lot of emails and said, this is what I believe are responsive. And in those emails were his electronic pay stubs. Well, obviously the municipality paid him and sent him an electronic pay stub. That's not subject to the Act, because that in fact is about his financial position, going to his bank and that type of thing. So notwithstanding that it was sent and it's within our possession, it can still be withheld, legally withheld. Right? And I think the biggest joke you see in a lot of cartoons is I put an federal request in and you see more black lines than written text. That's the reality of the 5 pieces of legislation. It allows us to protect the identity, protect personal information of parties. And so when you have a complaint coming from a resident that says, I don't want to give my name because I don't want my neighbor to know it's me, just because it's back when we get the big black marker out and redact anything that would suggest that it was a neighbor that we could complain. Sir?
Is the answer that whenever we send an email, we should be saying to ourselves, would we be embarrassed if this was sent to everybody? Is that not the question you really need to ask yourself?
It
Again,
would be helpful. Don't think you're politically correct.
It's true, but if it's about the municipal corporation, should we be embarrassed about speaking about the municipal corporation, the active municipal corporation? You always want to protect the interests, but if you're screwed up, let's call it what it is, let's deal with it head on. Let's not try to bury it, right? I completely get there are people out there that want to send you, but you're here because you were deemed to be be the right person to sit in that seat. You were here because you were open, you were transparent, and you will be held accountable. Don't fear that. Stand up to it, live up to it. And just because it's in a Hotmail account, again, eliminate computers and say, I received a letter from Mrs. Abernathy, and it's about something about the municipal corporation. That may have been written to you from a constituent, but if it has something tangible that will materially advance the business of the municipality, bring that record in, give it to Jessica, and let her enter it in as a record. And Mrs. Abernathy's name will be redacted if an MSF request comes in. So, again, try and think about email in the thin context as a piece of paper. So, Bill 8, oh my lord, it sent the clerks province-wide scurrying because it was so far-reaching. Now, why do we have Bill 8? I think one of the elected officials suggested it really came down to a gas line on the shores of Lake Ontario in Bolton. It really did. $1 billion boondoggle for the province of Ontario and deleted emails. But if the province of Ontario was going to be open and transparent and accountable for that $1 billion mistake, the municipalities are also going to be accountable. Bill 8 didn't introduce the regulation of email because something municipalities did. Bill 8 introduced email regulation because it was something the province of Ontario did. And if the province of Ontario can make a mistake, well, we are creatures of the province of Ontario. We exist because the province of Ontario allows us to exist. And they look and say, if we can make that mistake, so can everybody else. Will make and BIPA also protect electronic records. This is actually a very important slide because I've taken a look at Jessica's proposed policy for you, and I can honestly say it's exceptional and it's leading edge. And I will be using that policy as something that the county will also reflect on. So that's actually the next slide from your policy. I believe it's coming forward to you later this year.
No, it was approved at committee of the whole and then at council, and that's what is requested to have this training.
Oh. So, congratulations, you got the leading edge policy, and I'm even going to recommend that it be uploaded to the ACCO's website. We're calling that. It really is a good piece.
Careful about it.
Really is a really good piece.
There are royalties attached to this.
I'll take a vacation day.
No kidding.
So earlier on, I spoke about the offenses when an order is issued. This is what came out, a key provision in Bill 8, is no person, including elected officials, including staff, shall alter, conceal, or destroy a record or cause any other person to do so with the intention of denying a right of access. We saw that slide earlier. Everyone has the right of access to a record information controlled prosecution, and then you have 2 years. So if we find, if an individual finds out that you, in fact, they put an access request in, we denied access to that record because maybe it didn't exist, or we told them it didn't exist, and up to 2 years later, within your 4-year elected term, obviously, and I'll follow up in a minute, they can come back to you and say, look, the email that you said it didn't exist, here it is. So now you're out of office, and you think it's all good. Well, if it happened in 2018, you have 2 years. So even if you're out of office and that email comes up, there's a great potential for jeopardy. So Information Privacy Commissioner versus the Minister of Defense. The Information Privacy Commissioner in this scenario, this context, was federal Information Privacy Commissioner. And this was about the Minister of National Defense, again, using email about communication. and the provincial IPC have adopted a Supreme Court decision regarding a two-part test. Two-part test is, do the content of the document relate to departmental, and we can read that definition as being township matter. And I have a couple slides that emphasize what are township matters. And could the government or institution reasonably expect to obtain a copy of the document? And again, the Supreme Court suggests that your relationship with the township is so close, the answer is yes. So here we are. Do the contents of the document relate to departmental matter, the township matter? So the Federal Information Privacy Commissioner said, let's take a functional-based analysis. What is a constituency record and what is a departmental, what is a township record? So I went to the Municipal Act and said, what is a township record? And Section 11, sub 2, meaning you can adopt bylaws governing structure, accountability, transparency, financial management, public assets, economic, social, environmental, health, safety. It's a large list. Function analysis continues. Sub 3, highways, transportation, waste management, public utilities, culture, parks, recreation. It goes on and goes on and goes on. It's quite extensive. Everything that you do, look there. That's what you do. That's what we have oversight. And it goes on. Function-based analysis, section 224. What is the role of council? Represent the public and consider the well-being and interest, develop, evaluate the policies. This one here, D1, to ensure the accountability and transparency of the operations of the municipality. Right there, black and white, what is your role? Accountability, transparency of the operations. If you make a decision that materially advances the business of the municipality, D1 speaks specifically to you. Sir?
So if you're just flying some information, somebody sends you an email and says, can you fix the swings down the park? And you'll say, I'll talk to Brad, or go and talk to Brad. Is that something I have to keep? You know,
so it's hard for me to generalize, but I'm going to suggest to you, you're walking your dog and Mrs. Jones comes along and says, my grandkids are over, the swings are quite rusty. It's like, you know what, I'll talk to Brad about the rusty swings. It's so innocuous, it's in passing. You're going to say, hey Brad, there's a swing down there, right? There was a park down there, we'll take a look at it in the next cycle. I'm going to suggest to you on higher level, that's a constituency concern with you. You went over, you took a look at the swings, they're rusty, you told Brad they're rusty. But that's a slippery slope, because you're going to now say, well, this haven't actually talked about, I can start fantasizing about all the other options that meet that same criteria. It really has to be on an individual basis. Is it impacted? Is it innocuous? Chances are you're probably fine without the record. But in doubt, make the record, right? Does it materially advance the business of the municipality? Does it relate to the business of the municipality? The list is quite extensive. It's parks, it's recs, it's culture, it's health and safety. It runs the full gamut. So if what you're being asked to do, extend funds, what you're asked to do is give direction to staff, the chances are it's going to meet the criteria of the record. Right? Sir?
Of course, we've been trying to review all the material that's been sent to us, but there's obviously thousands and thousands, you said many different things that we're responsible for disclosing. With planning, we have a list of 4 test lists. If it meets the criteria of those 4 tests, then we're getting involved. The reverse of what you're saying is what I would like to know is what is exempt from this. And I know from my research that, if you're going to create physical harm to anyone by disclosing the email, then that's exempt. There's a few that I went through. The rights to a fair trial, things like that. Is it possible that you have a list, or there could be a list of emails or communications that are exempt from the freedom of information?
I can only suggest to you that, given the September 2014 order against a Toronto police officer, and given the Oshawa February, March, the 2015-2016 Oshawa ruling, that list is very small, and in as much as I say it in fact be exempt, the constituency records may be exempt, it's not up to individual municipal councillors to apply the legislation. That's up to the head of the institution under the Act. That's your municipal clerk. Because I showed you the list that last night at 8 p.m. the ITC issued a couple of new orders, and the application of the Act has changed. That's up to the municipal clerk to decide. Simply because you give it to the municipal clerk, it may be exempt, and therefore she will identify on those. When we respond to applicants, we still need to list what we identified as being responsive, but we say it was held in its entirety or it was held in part. And we cite which pieces of legislation and conceivably which orders empower us to withhold that information. Then the ITC will take that. If there's an appeal, the ITC will look at that list and then say, yeah, you're good, or we get a mediation and they make us take second reflection on that. If we're not satisfied, then we go into adjudication. If we're not satisfied with adjudication, then we're doing judicial review. And judicial review, the price tag easily starts at about $10,000 and months. Our judicial review in Springwater is set to be heard by September.
So is there a process in place when I've surrendered all of my emails that were requested from me? Can the clerk come back to me and say, Brian, all these emails are being sent in except for this and this and part of this and part of this. We've excluded those. Is it my right to have that information from our clerk?
Sorry, I'm not
If I surrender 100 emails and our clerk goes through them and says, we're going to release all of these to the person who requested it except for 4, which are of a personal nature or do not qualify, will I be notified that those 4 were not given, or can I request which ones were not forwarded?
I'm going to suggest yes. You're having a good relationship with the clerk, especially when you start getting into this new territory of your personal account. You should be comfortable that you are part of the process.
But we're not told who the requester is.
You're not entitled to that.
That's not part of the process, isn't it?
I don't mind telling you this. I was at the Institute conference in June, and the ITC were there, and the provincial ombudsman was there. I am such a strong advocate for openness and transparency in municipal government. I also believe the individual that is filing a complaint and filing an access request should also be open and transparent and accountable for their access requests. I don't mind telling you both the IBC and the Ombudsman Office disagree with me. And that's fine. A lot of people disagree with my approach. I didn't think being open, transparent, and accountable was something you couldn't disagree on. The point they were making is, if Ms. Abernathy is complaining about their neighbor, because the neighbor is negligent and the sewage is leaking across the property onto her property, she doesn't need harassment. She doesn't need any undue pressures on her. So protecting her identity in those scenarios so she can enjoy her property is appropriate. And I get that. Because when you travel into larger municipalities, you will get a lot, I don't know how many access requests you get down here. Toronto, on average, is about 5,000 access requests a year. In the region of Peel, we were about 112. Depending on your population, your number of access requests will likely dwindle, because I guess more people have something else to do. Right, something more valuable to do at the time, if I would suggest it. But it really comes down to, if they're putting an access request in, it has everything to do with, something's not quite right with them. So the access request that Jessica will release, and all the redactions, I don't know what the practice is here, but that entire access request, once we release it once, it's in fact in the public domain. That person can print it in the local newspaper. So there's nothing wrong with just, in fact, publishing all those emails on your website under what's called active dissemination. If it's out there, give it to everybody, right? It avoids the next access request for coming in. Okay, so function-based analysis, you can see the list of things that you need to do is quite lengthy, and role of municipal councillor. And I said under section 224 of the Municipal Act, this is the role, this is published by the Ministry of Municipal Affairs and Housing. And they identified that you have three key roles of representatives. That's your constituencies. The policy making and the stewardship role. The next paragraph is, in fact, integral for you as well, along with Anne's paragraph earlier. The roles may often overlap. You will be called on to consider and make decisions on issues that will sometimes be complex and controversial. Many of those decisions will have long-term consequences for your municipality that extend beyond your four-year term of office, and should be made in the context of your municipality's directions for long-term health and welfare of the community. And I put some emphasis here. These roles may often overlap. You will be called on to make a decision that will extend beyond your four-year term. So think about that. If you have an email or a piece of correspondence that materially advances the business of the municipality and you leave office, and the municipality is still subject to the decision that you made, but in absence of that information, the next council comes in, the next administration, if there's staff turnover, retirement, that type of thing, their absence of knowledge. How do we make that decision? There is nothing in writing. Again, the decisions you make today, whether it's via email or paper, will live on beyond your four-year term, and it's appropriate that the institution be aware of that information and how you make that decision. We're going to talk about the Oshawa case momentarily. Here's Oshawa. Let me just advance my slide back here too. So the councillor's email asked the investigator, George Rusty I. He's going to be their closing investigator. The elected official asked George, what do you think about the agreement we're making for you? What the staff was the elected official, was the councillor, who's emailing George back and forth. The final motion contains detailed information about the terms of the investigator's engagement. In other words, the councillor laid the groundwork for the city's decision to engage the investigator and the terms in which it did so. The city admits that it has not relied on the record. However, its creation played a significant role in the council's decision to hire the investigator in the vote that took place later that day. Laid the groundwork. She negotiated with George the contract which would be ratified in that type of council. That's serious, isn't it? No. So I ask you, in that scenario, that one email, again, let's even take email away. I wrote it on a piece of paper. George, here's the agreement. I've added a couple of paragraphs. You think that's a good amendment? George says yes. Councillor goes into the council chamber that night and says, I've made some changes to George's proposed contract. These are the changes. I've talked to George. George agrees. All those in favor, and we're done. But what is even an email? It was on paper. That handwritten document materially advances the business of the municipality. Her email did the exact same thing. It materially advanced the business of the municipality, and a decision was made based on that email. That's really where you should be focusing, is are you materially advancing the business? It's not the small, innocuous, rusty change. that truly materially advance business. It's when you're hiring someone for tens of thousands of dollars to conduct closing investigations. And that's the funny thing about the Oshawa case, isn't it? We're going to talk about serial emails in a minute as well. They were hiring a closing investigator, and she was conducting business off to the side, out of the limelight. And she could have sent that email to all the council and said, here's the recommended changes to George's contract. Everyone think it's good? Okay, that's what I'll introduce tonight. There is a closed meeting investigation of George. They just hired $10,000 or several $1,000. In fact, will have to recuse himself because he was the subject of the closed meeting replacement by serial email. Right? Accountability, transparency. The council laid the groundwork for the decision. Its creation played a significant role in the council's decision. That's my emphasis for you in the Oshawa case. There's a lot of talk out there. You can Google it. A lot of lawyers out there saying custody control. That's the real issue here. The difference in Oshawa compared to my experience Springwater or and now what's going on with Simcoe. In Oshawa, the elected official said, "Oh, here's the email." And of course, print. Here's the email, and hence the municipality became in custody control. So custody control was a big thing for a lot of lawyers, saying, "Well, if she had not given that email, then custody control would be in question." It's my opinion that it is not in question. The FTC have already made the decision back in September 2014 against the Toronto Police Service when they said the police officer must give us access to his Hotmail account because he materially advanced the business of the Toronto Police Service. In Oshawa, the fact that she gave it, that was just procedure. It was just, she just gave it. You know, yeah, we hired Rusty, used to have a record, here it is. You know,
Here's an example. If an individual is going to be a delegate at a council meeting, and that individual came to me and said, "Here's my presentation, what do you think?" And I said, "Well, why don't you add this, this, and this, and this?" It might have, an effect on council's decision. And this is all hypothetical, by the way. But I suggested, this is what council wants to hear from you. And he said, "Great, that's what I want to know." So he puts that all into his delegation. And he comes here, gives a delegation, and council makes a decision on that. Have I done something wrong? I've helped him give some insight into what council wants to hear.
Yeah. Again, I want to be cautious on certain folks. When I told Ray to set it comes to delegation, I tell the delegation that I need your PowerPoint slide deck in advance of the council meeting. I need my council to burn through the learning curve on the subject that you're coming to speak about. I want them to read your slide deck before you get in the room. I want them to read it. I want them to have questions about what you're going to say. And when they sit down, you help this individual, your hand goes up and you're going to say, "Your Worship, I met with Mr. Jones, or spoke with Mr. Jones, and he told me what he was going to present tonight, and I told him, great idea, bad idea, and I told him that you need to hit these points." You're being open, you're being transparent. You're not being subversive in the background saying, I'm guiding the delegation to get materially against your agenda. Right? So, speaking with your constituents, helping them to be effective at this table. I'm going to suggest nothing wrong with that.
Okay.
It's important to be open, to be transparent.
But I must admit that type of phone calls we get, I have to talk to Brad about, somebody will phone me and say, I have to talk to Brad about something. How should I approach him? Or, what do you think? Will you do this for me? And I'll say, well, maybe if you change this and so on, he might. So I give them advice of how to approach staff, how to deal with staff and so on, because when they come to staff, they want to be prepared.
Right.
So.
Yeah, plus Brad's phone number. Right?
Well, yeah, no, but, you know, would they do this, or am I wasting my time asking staff to do this? Like, this is what they come to me to say. So I'm just basically helping them and giving them advice of how to approach staff and what we can and cannot do.
So you're representing your constituents.
Yeah.
Right? And the legislation is not telling you cannot represent your constituents. It's saying, bring materially advanced business in this valley, create the record or provide the record. So here's a little bit from the Supreme Court decision. De facto as opposed to de jure. Control is recognized as control. Although a councillor is not considered to be part of the city for the purpose of the Act, neither is the councillor a stranger to the city. Both are governed by the Municipal Act, Section 224. So de facto is being such an effect, though not formally recognized. So we now have a policy that says that's going to govern information, right? That would be de jure. But the Supreme Court has said, even without your policy, your relationship is so intertwined, it's so close, that your business sometimes is in that gray area. It's so fine to the line, it may very well be subject to the Act. It's not constituency, phone calls about how do I get a hold of Brad. It's in fact corporate record. The Supreme Court is that, I'm going to call it that aha moment that a lot of elected officials, a lot of municipalities were looking at when it came out. And it is a rock-solid foundation for any municipal clerk to reflect on when we're applying OSHWA, and soon we'll have an order with Springwater, and soon we'll have an order with Aurora, and then there will be no question across municipalities how the Act is to be applied. And you saw that list as of 8 o'clock last night. Springwater, Aurora, Simcoe will appear on that list. Jessica will use that order to apply the legislation against any emails that we have. So this is related to your policy that you adopted, control of the record. I will read those two paragraphs to you, but your policy now addresses appropriately custody and control. So here we are about constituencies. A constituency is the body of voters in a specified area who will elect to represent a member of legislative body, council. The term constituency record may be understood to mean a record that deals with political activities of an elected official of a local body. So think about the political side of things. It's really easy for us to look at the provincial government and the federal government and say, political party versus government. The Prime Minister is government, but he is also the head of a political party. Not so easy here in the municipal sector, is it? Right? We're an elected official. We don't have parties. Constituency record may include an inquiry about an activity in the constituency. So again, Ms. Abernathy saying, who should I speak to regarding the subject bed? And it may very well, when it comes election time, you're going to be talking about politics heavily in your account. So this slide, I think, sums up when we're talking about constituency. The action really does speak. Are you advising, are you guiding a constituent regarding service delivery or availability? Where can I park my boat overnight? What are the charges, the mooring fees if we operate a marina? Or are you seeking to take an action, materially advance business? Advising constituent, taking an action based on constituency information or information that you're in possession of. So serial emails. This was new. I actually called the Lumberton's office about 2 years ago, and I asked them about serial emails and what constitutes a a meeting. And you've heard me say a number of times, materially advance the business. And really, they were saying, well, I can't tell you, John, you should call a lawyer. But here's a couple of decisions by the Ombudsman's office that may help you. And the message that kept on coming out was, is it about the business of the municipality? Does it materially advance the business of the municipality? It doesn't mean that we're physically in this room anymore. It means that I sent an email around the council, and then when we came into the council office, the agenda item came up, controversial agenda item. Everyone handed it up without any major discussion, because you had that debate discussion via email. It wasn't open, it wasn't transparent, and you're not being accountable. So the Ombudsman issued 2 recommendations for ethics. Avoid exercising the power or authority of council, laying the groundwork necessary through those emails. The groundwork necessary is the exact same language that the Oshawa case issued by the IPC. So now the Ombudsman's office recognizes groundwork, and the IPC acknowledges groundwork. Serial emails, again, from the Keller, they contravene the Municipal Act and Municipality Procedure Bylaw by holding a closed meeting and a vote over email, the straw votes, right? Okay, we're not voting, but how many of you agree with me? If it's about municipal business, it's more likely to be a record and should routinely be provided to the clerk upon request. If it's about municipal business, it's ill-advised to conduct straw polls, business via email, due to the potential of serial email advancing the business of the municipality. So in my former municipality, we deployed records and information management, ERMS. So when I had an email, and I knew it was a record, I would in fact I would copy records as framework. That's all I had to do. I knew it was a record, and I pushed send, and it would automatically file it for us in our repository. My obligation was complete. If you feel that you are sending an email that is a record, you can, I'm going to suggest copying your records or copying your clerk, or after you send it, forward a copy of it to your clerk. That way it will, the clerk can make the decision whether or not it's in fact a record, and she will take care of filing it accordingly. I'm not a fan of BCC, blind carbon copy, right? No one gets to see what BCC, because I started my presentation by saying I am a big advocate for openness, transparency, and accountability. And by using the blind carbon copy, BCC, you are not being open, you are not being transparent, you are not being accountable. What is wrong with telling your constituents or whomever you're emailing that you're sending it to the clerk? You're telling the township that this issue is going on. Open, transparent, and accountable. If you think it's a record, nothing wrong with giving it to Jessica or your records so it can be managed. And that is my hour. Sir?
One of the debates I know we've had back and forth in this township is the issue of closed session. And we seem to have a high number of closed session items. And I think that's where we get a lot of concern from our constituents, because they're saying, well, they made a decision, there's something going on. And any comments on that? Is that your expertise?
Well, I'm a municipal clerk for subject matter experts on it, because I'm being a municipal clerk, I can tell you going to closed session is like every other municipal council, and just like every other municipality, there are municipal advocates out there that wonder why you've gone to closed session. All I can tell you is, as a municipal clerk, we do not go into closed session easily. It needs to meet the threshold. we're selling property or it's a personnel matter or personally identifiable individual, whatever the case is, do not go in easily. And there's a lot of, I haven't seen your agenda when it comes to closed session. There is a requirement for you to adopt a resolution and state why you're going into closed session. That is being open and transparent. We're going into closed session, we're going to talk about personnel matter. We're going to close session to talk about litigation. I completely get that Mrs. Abernathy wants to know about the personnel matter, and she wants to know who you're litigating against. But the legislation allows you to go into closed session. I'm also going to tell you that you're not obligated to go into closed session, but you are obligated to protect information. So, as much as there might be 4 items on your closed session agenda, does anyone wish to go into closed session and talk about the 4 items? No. Okay, well, you still have a staff recommendation to adopt after that. But again, there's always inquiring minds. Don't fear going to closed session because you're authorized to do it.
But I've been on council for 6 years. I don't believe there's been a council meeting where we haven't had a closed session.
I remember one.
You remember one? I just get concerned because, it really gets the public all excited that, there must be a lot of things going on that, they don't want us to know about. So,
but again, before you go into closed session, you're saying litigation, potential litigation. We're going in because we're suing or we're being sued.
but you can use, anybody can sue anybody for anything. I've been involved with clients who were sued, spent $1 million on legal fees, and nobody got anywhere. So, I think that one can be, you can say litigation about anything. You say that's black, I say it's white, okay, we're going to go to court.
It has to be, in fact, the potential, not the
I hear you.
not the differing potential, but actually the potential. You can serve notice, essentially, in one way or another. It's not just hey, I'm going to litigate, right? That's not the potential. If you had a traffic accident, township vehicle crashed into another car, that's a significant potential that litigation is going to happen, right? It's not after going into warrant to say, I'm going to sue. Oh, that's good enough reason to go to closed session. No, that's really measure the true nature of that statement and the likelihood and the potential. So I'm going to suggest that in as much as you may feel you go into closed session a lot, you're entitled to go into closed session because you're entitled to protect information that the personal information or part of your defense in court, right? The defense, nothing would make a lawyer happy but to know everything about the defense, right? So,
Peter?
Just on closed sessions, since this was already raised, I recall having a training session with Rick O'Connor from Ottawa. And so I'd be interested in hearing what you have to say about this, because he said something along the lines, and I may be somewhat off base here, but I don't think very far. He said something like, in the last 7 or 8 years, Ottawa had gone into 5 sessions or 6 sessions, something like that, in that period of time, A, and B, of every one of those sessions, except for one, it was related to negotiations with the QP or the employees of the City of Ottawa. And so one has to ask oneself then, how does Ottawa pull that off and we can't? And I guess, sort of supplemental to that, is it because they have a lot of committee work that's done as opposed to the way we operate, which is the council is your committee. At our district in Muskoka, there's a lot of committee work, so not that it's in closed session, but for some reason, there seems to be, on a district level, very little closed session, almost maybe once or twice a year, or something like that. So, could you maybe expand on that?
yeah, I'm fully aware of Rick's record on not going into closed session. And it's important to also take it into context that, and I don't know the answer, but I believe strongly that a city the size of Ottawa, and the regulations being in the capital, have a lot of delegation. So I'm uncertain the level of delegation to the CAO. But the CAO is empowered to hire fire discipline from to the fullest extent and not to report to council. And you're not going to closed session to deal with the personnel matter. If you delegated authority to buy and sell property, then you're not going into closed session to deal with buy and sell property. So again, I was in a similar presentation with Rick, who's a very knowledgeable clerk, he's also a solicitor, right? So when he says something, we can take it on face value as much as solicitors, depending on whose side you're paying, I have to tell you, but it's a wonderful record that Ottawa has. But how do we get there? Chances are it's a delegation of authority for which this council is authorized to do.
So just supplemental, if you don't mind, and that is, so you've gotten to the nub of the issue, which is, instead of it being delegated to committees, in fact, it's been delegated to staff in this particular case. And so the staff a lot of these issues are not coming to council, staff are making those decisions. Council in Ottawa has delegated that authority to those individuals to make the decisions, and unless it's a real bomb, so to speak, it probably doesn't come to council.
Exactly.
We've kind of strayed from the FOI here, but you did hit the nail on the head. Delegation or an in-house lawyer, okay, is...
I didn't say in-house lawyer.
That's the reason district doesn't have so many closed sessions to deal with things.
Delegation
The upper
is,
management and the lawyer, they solve or resolve most of the issues unless it is a real bomb. So,
we're just here, and Lori, when we're entering into an agreement, does the agreement come before council for ratification? So, in my previous municipality in Springwater, where we award something under a procurement bylaw, we went out, we were into a public forum, we were fully accountable, we were transparent, we were going to award $100,000 for new trucks or whatever the case is. We also had a delegation of authority bylaw, it was called what I recently call it the routine document execution bylaw, and it said that if you're acting in accordance with a council resolution or another bylaw, such as purchasing bylaw, then staff can go ahead and execute all the agreements with supporting that issue. That matter never came before council, because before council's already said, go out and procurement and follow these rules in your procurement. If you don't follow those rules, or you can't follow those rules, that's when you're going to come to council and ask for those exceptions. But delegation of authority is likely where Rick achieved his success in that area.
So we do have that, just at a different threshold than you're used to. But just to put in context for you, the reason that we're typically in closed session is because we have a lot of formal hearings. So we're in closed session getting council's strategy, and that's something that we couldn't do in open session.
Yeah.
And that's not delegated to staff, nor ever would be, so that.
Let's get an in-house lawyer.
Even then, my experience with council was still want to participate in the strategy. That's typically why we're in closed session.
Brian?
Glad you freedom of information. If an organization, say F or XYZ Cottage Association requests my emails, and I go through my email server, and I'm no expert in editing email servers, but I go in and I punch in XYZ Cottage Association, and it comes up with all the emails associated to that in the topic line. I surrender those to our clerk. She reviews them and releases whatever she feels she needs to release. Then this XYZ Cottage Association comes back and says, well, hey, what about this one? I got this one sent to me via a friend of a friend of a friend, and it's not on that list. Okay, so all of a sudden, I'm contravening the act and I'm not surrendering all my emails. As I said earlier in the statement, I'm not an expert at editing my email server. It's all over the place. For me to do what I did took me about 8 hours to do it. The cost of me doing it is inhibited because I'm a very expensive person to hire. And I understand that there is, when cost is an inhibiting factor, that comes into play. But what am I going to suffer by not releasing all the emails? Because I didn't find every single one that was related to that, because XYZ was not in the topic line or wasn't in the body of the text itself, and hence I wasn't able to find it, but they have.
Yeah, it's a great question. First of all, did you intend to not disclose that email?
No.
We had no intent to mislead, obscure, hide, delete an email that's under request. That's an important distinction. The second thing is, it turns to Jessica and how she will process the access request. Jessica will likely say, we have asked our elected officials to conduct a search using the following criteria. And this is what we got out of it. Who uses? You don't have to put your hand up, but there's Gmail, there's Hotmail, there's Outlook, there's Simpatico, there's at Georgian Bay Township, and each one of those Hotmail accounts, each one of those email servers, systems, have a different way of searching. So, it is very complex, but likely Jessica will give you and say, we're searching for XYZ association, please conduct a search using this XYZ. Right? Not XYT, XYZ. And again, in her letter saying, we asked our elected officials to conduct a search at this time frame to this time frame for XYZ. These are the records that would be responsive. And I've had an access request. I don't mind telling you that an email was later found by staff that, for whatever reason, didn't come out, and we issued an amended decision. So it's not the end of the road. It's all about what was your intent. But we're documenting in the decision how we conduct the search. Now, as it relates to your expensive hour, there are fee structures that the IPC allow. And it's a complex formula. There is best practice. Jessica is going to be well aware of what you can charge for. But it's very limited, and it's at $7.50 every 15 minutes. That represents $30 an hour.
Right.
$30 an hour rarely covers the cost of staff, time, and process. The cost of making access requests is $5. The Township of Oro Medonte, I don't want to call them out, but they processed an access request and spent $60,000 to conduct a forensic audit of their email service, and then issue the fee estimate, $60,000 plus that time. And the requester said, yeah, I'm not investing anymore. So they come to the fee estimate and the cost. Jessica knows how to apply it and get as much money back. The IPC has now been asked by a number of municipalities, I'd be surprised if we haven't seen the letter, to say we need to amend the legislation to allow us to recover fees and expenses.
To supplement to that, there is caps in place in foreign countries. I know a corporation in England, and we have a Freedom of Information Act, and the cost for my staff to do that exceeded £600, and because it exceeded £600, we did not have to conform to the order. And I'm wondering if in Ontario they have a similar cap, where if it's going to cost over X number of dollars, then you can say it's too cost prohibitive, we can't do this.
The answer is no. As long as the requester is willing to pay, they're allowed to collect 50% of the total estimated cost. before you can start the work.
So it's the responsibility of the requester to pay for that.
Correct.
Thank you.
Well, since it's a training program, what are our costs, Jessica? What are our fees?
$7.50 every 15 minutes,
Okay.
and 15 cents a copy, a photocopy.
Okay.
So when
So
we-
say the average request, how much would an average request? Like I want emails for the last 2 years or something like that. What would it?
It all depends. I can't answer an average request. We don't get average requests here. So I can say the most recent one we've had, it goes anywhere between $30 and $60. It's not total. So what we do is before we get the package ready to send out, we send them a letter saying, we've done the search of the records, this is how much it is, give us a check, and then we will release the information to you. Half of the time, when we send that letter out, we don't hear back. They decided they don't longer want it. So then we've lost the staff time.
We gotta bill it beforehand.
Well, then,
We don't know how long it's going to be before.
but then do you tell the people that your emails weren't needed, like?
I can't answer that.
How do we solve this problem? Because this doesn't make sense for us to do the work and then the person to say, oh no, I'm not gonna pay for it. I want a contract first, you're gonna pay. And we don't pay when it reaches $100.
To be clear, we're not necessarily doing that $60,000 search before they pay anything. We're obligated as a municipality to give them an estimate. So Justin may very well say, okay, there's going to be 10,000 pages at 15 cents a page, and I'm entitled to $7.50 every 15 minutes. Here's the estimate. Even before I start getting my black marker out, here's the estimate, give me 50%. They walk away. Still doesn't recover Justin's time identifying the 10,000 pages, which she required to give you the estimate.
How much time do you have to put into the estimate? Because you could say, it's gonna be at least $100.
Again, the best practice by the ITC dictate what we're allowed to charge for staff time involved in conducting search and other records.
Thank you, that answers all my questions. Okay,
Great, my pleasure.
Thank you very much. And you provide your card, because if I do have some more questions, I can phone you, is that okay?
I'm going to encourage you to go through Jessica.
I
can charge it
Comes to the record. Remember, he's gonna use her policy.
Yeah, I'm using Jessica's policies. I definitely go through Jessica, and if there's any requirement, we can wrap it up.
Okay.
Thank you very much.
Thank you very much. And let's take a 7-minute break.
Yeah, we need to have our town meetings
Makes you want to continue being a council?
Yeah. Serving your municipality.
Joy is a democracy. I'm always saying, it's fine if we have benevolent dictators. It's the question, who would be the dictator?
Now, that would be cool. And next tree you look behind us.
How many hours left, Jim?
Have you noticed how happy Jim is looking these last few weeks? Oh, he's smiling.
Yeah.
I always thought it was from his long trip that he took in the Caribbean, but you know, that wore off after a while. I figured out that's where he's going in the next few.
Hey, did you get those dogs?
I did, thank you.
Awesome.
Yes, thank you very much. And once they're all installed, three have been installed, two are rafted right now because we just had to, they're at the beach.
Great.
2 days.
Not in our yard.
Yeah, well, you're in the past year, and I thought, oh, nice. No, we'll put them to good use. Yeah, I'll take a picture once, they're all in place.
Okay, fantastic.
Yeah, just big them.
I'm glad that they're getting used. That's,
Hey, you know what? The beach never looks so good.
These little parts,
Very
I noticed that all
I've
this
heard so many comments, and I'm pretty sure I'm
Israel
going to
list
see
of
that.
that $2,000 fee.
rules that come up.
All good. Great.
Comes out all the time.
I mean, this should be considered just things to make people think.
Yeah, I'll see what I can find.
No, I would tune in every once in a while. When you get up the slide, there you see pop ahead for the rest. Was there him and a girl? Oh,
Well, he is full.
so, I was there.
And you got all the answers.
Is that on the side?
Oh, boy, talk about a broken
This is a number of letters.
Ron, you looking for me?
No, I'm going to meet with Karen now about payroll, because I'm sure I gave her information, so I'm not sure.
Well, she said you're looking for me for,
Yeah, two of them.
I had typed out my resolution and just like put it on the resolution format that you like me to do.
So, are we all here?
Except for next item for her. So you probably need her. She's coming.
Anybody signed up for open forum?
Okay.
The audience looks.
No audience.
Fairly thin. So I guess no.
Find out who makes this coffee, get them to come to my house and teach my wife how to make coffee.
Your wife's probably watching.
Oh, that's all.
That's on camera, We've bought 2 Keurig machines in the last 2 weeks and both fill our cup with coffee now.
Oh, yes.
No, we bought the newest one and then we went back to the classic 2.0 and still put a thing in, put it down, get my cup and it's got a quarter inch of ground. And we tried 3 different K-cups. I don't know what's going on.
French press.
Yep, that's all that is.
That's how we make our tea, but not the coffee.
I take a lot of coffee.
That's the way it was.
Very expensive way to do it.
That's a cup, 75% the cup.
And the amount of waste. My wife really uses it all.
Still burned out.
Oh, don't hide, nothing happened. What are you trying to
Lay it on it. Shines on my paper.
I found out what's wrong, I'm using open office, not Word. The open office is converting into this.
Okay, folks, call the meeting back to order. We're still on the first item. I have a resolution moved by Councilor Bochek, seconded by Councilor Edwards. Be it resolved that Committee of the Whole recommends that Council direct staff to undertake the follow-up steps outlined in the report. That Committee of the Whole recommends that Council further direct staff to 6 bullets here. Ensure a focus is put on planning education, in particular the planning education session to be given on July 23rd, 2016 will be used as a template to be offered to other cottage associations on demand, with feedback provided for improvements by the councillors in attendance. Second bullet, bring a more comprehensive report to COW for discussion on service levels desired for enforcement and related staffing requirements in the fall as part of the budget deliberations, recognizing improved enforcement is a desire of the community leaders. Next bullet, bring a report for discussion to COW on potential changes to the septic inspection program as part of the budget process. Next one, bring a report for discussion to COW on potential changes to the Township grant program during the budget process. Next one, connect with the communication volunteers on cottage associations to see if they would assist in disseminating Township communications. And the last one, direct Councillor Cooper to work with Bob Duncanson of the GBA to create a small, geographically representative working group to promote voter engagement and improve the voters list.
send this specifically out to those in attendance, or all association heads, plus any other organization, SEGVA, et cetera, so that we specifically set this out with the idea that we would like any thoughts or input you have with regard to this. I think we should encourage community engagement.
All right.
Could we also send it to the people that weren't in attendance, say the Moore Point people, Fred Waring, or whoever, the people that weren't at the meeting?
Again, so Mr. Duncan can arrange the group, and he had a list, so anybody that was on the list.
Most people are mostly on his list, they may not have attended.
Yes.
Everybody's okay? We'll vote. Okay, good enough. Then we'll
I did that.
not do a straw vote. We'll do at lunchtime. Okay, all those in favor? And that's carries. Thank you. Procedure bylaw update. Moved by Councilor Douglas, seconded by Councilor Wienko. Be it resolved, the Committee of the Whole recommends that Council adopt bylaw 2016-61, which repeals bylaw 2016-22, being the Township of Georgian Bay procedural bylaw. Madam Clerk.
Just to highlight the 4 changes that we are suggesting in the procedural bylaw, suggesting that delegations be scheduled prior to the public meeting, so they have a definite time of what time to be here, and they're not sitting through any sort of unforeseen lengthy public meeting. I think you all remember, it may have been the last meeting where we had delegations set for 10 a.m. and they didn't speak until about 2. So the other thing about delegations, that we're proposing that if there was an application or a matter that has a public process, as a open house for planning, they no longer be allowed to delegate because they already have their public opportunity to speak to members of council. The other change is change to the closed session agenda, basically not having a separate closed session agenda that gets sent to councilors, but the agenda items are still in your confidential portal that you access now. The access would be the same thing. And then the last change we are proposing is when other municipalities send us resolutions for concurrence or for consent, they can often take up the first 100 to 150 pages of agenda. So what we are proposing is sending them out to council once a week with all the ones that we receive, and whatever ones you would like to discuss or possibly vote on, you can let me know and we can add those to the agenda.
With no debate on email.
With no debate on email. Those are the changes.
Councilor Wienko.
I just have a couple of questions. On page 24, you talk about voting in closed session and talk about the only votes that may be taken during the closed session of the council are with respect to the direction of staff or agents of the municipality or vote procedural matters, deferral, referral, or tabling. What other votes are there?
For example, if someone brings a report to closed session and there's a resolution stating, be it resolved, council receives report for information only, according to the act, you don't have the opportunity to pass this resolution. Only action items.
Okay, I just couldn't think of any other things to vote on. Okay, the other one too is on this the issue of delegations, that they made a presentation at a public meeting, and they're not allowed to come back. Is that on an individual basis or on, say, an association basis?
It's on a planning application basis. If they've already had their opportunity to speak, or say a public meeting is coming up in the next public meeting, and they're going to have their full opportunity to speak then. When people schedule a delegation to talk to something, they will already have the opportunity to address you about. It takes up the 2 delegation spots we have in our bylaw, the people who want to talk about things that are not a public process.
But I'm worried about getting up-to-date information or new information that might have come up between the public meeting and our decision-making at the council table. If there's new information out there, then we may be denied that information because the individual did not bring us that of information at a forum like this. So there has to be some way that new information can come to us. And so maybe we have to get them to write an email or something like that. But I hate to say to deny somebody the opportunity to provide new information that we need.
If there is new information, it would be reflected in a staff report that would come to you at a later date. If, say, the public meeting was deferred, and everyone who wants to delegate on something is already full, for instance, they are advised to send an email to council so you're aware of their.
I'm still concerned about that. I wouldn't mind getting other councilors' opinion on that, but I hate to have denied people's rights to talk.
Laura, you had something?
Jeff covered it. I'll wait for a moment, thank you.
Councilor Edwards?
Question on who can delegate. So one of the issues, I've never dug into, but Jean DeMarco said she had requested the ability to come and delegate to council and was told that she couldn't. And yet we had the developer put on a very long presentation. Can anybody make a delegation, or are some people excluded from making delegations? I don't know our rules.
So anybody can come and do delegations. When we were going through the zoning bylaw process, though, we directed everyone who wanted to talk about the zoning bylaw specifically to one of the 4 public meetings that we had. So we didn't let people come and delegate on the zoning bylaw.
But we let Talisker come in and make a very long presentation, and he didn't let the representative of the community group come in and speak. I mean, something's wrong with this.
I don't believe Talisker was talking about the zoning. They came and made a presentation about their ideas.
Well, I don't know.
We didn't look into presentations versus delegations. Like up at district, or if we have district people here, that's typically a presentation, not just a delegation.
So we moved, the rest of council, Mary and I had this discussion, and I didn't remember discussing Jessica, which is why she's looking at it confused, but I think we can probably do a better job when it's more staff-like. So when it's district, we can put that in staff report, so it's not picking up one of our 2 delegations, so that's good. And that's fine, we can do that. We've been really finding a lot of delegations, and we've been relaxing the rules, which is not a good thing for us to do, because when we have somebody come on a planning process that they've already spoken to, typically it's a controversial one, so they're pro or against whatever the matter is before. So if we let the pro side come, then to make sure the council gets balanced, then we slip in another one who's the opposite side. So that's why Jessica and I had discussed that there is a public process. So people get their say as part of that public process. If they have new information, then they can send an email, they can write a letter, they can let me know. There are avenues, but it really has taken up a lot of delegation time lately. And then people that are asking for delegations have said, we're available now in October, because we only take 2. And we're finding council days are pretty long because we do the public meeting process. We're trying to streamline it in a way that still gives people their opportunity.
Councilor Randall?
I'm concerned that when people want to delegate, they phone up and say, well, the spot's are already gone. That may not be fair. I think we should have, say, okay, certain dates, say the 2 Fridays before the council. Anybody wants to delegate has to get their request in by that particular date. And then you decide out of the 5, which 2 are going to be done. I know, but I'm saying maybe we should review that and say, okay, have a deadline for the delegations and say, okay, out of these 5, these are the most 2 important
Who
ones.
makes that decision?
That way you have to do the work. But the point is, I can say I want to delegate, and it's about doing that. It's minor issues, a minor issue, and I think that's a valuable thought for somebody that
It
wants
could be
to.
10 years before his delegation came to council.
Well, I think we should.
First come, first served, sorry.
I think
Lori?
it has to be first come, first served. Councilor Evans
I
just
disagree.
gave you an example that he didn't agree with the decision that I made. So I don't want to be in that position to decide what's important and what isn't. First come, first served. There is a deadline before the agenda is published, but they're always full. I bet you look
sir.
Just for clarity, because I'm not understanding what the analysis is on the delegations. It says 2 delegations, a maximum of 15 minutes. I've sat here, well, we've had delegations that last 30 minutes, 40 minutes, an hour, say from the Severn Sound environmental groups or whatever. And it's all great, I love it. I love to sit here and listen to that. And on the other hand, we have a delegation and an alarm goes off and it's your done, get out of here. I'm just wondering, if it's a policy or a procedure, then we have to adhere to it, but I see a big difference between somebody who stands up with a slide presentation for 45 minutes as opposed to somebody coming in and the buzzer goes off and you have to leave. So where do we stand on that?
I think we come back to what's a delegation and what's a presentation. Okay, if it's Severn Sound, that should be under a staff type of arrangement. If it's district with the water quality, it should be under a heading of a staffing thing. A delegation is an individual coming before us stating their point. And if they can't state their point in 10 minutes, as far as I'm concerned, then they're putting us all to sleep.
Right, but we have, supplementing that, we have had delegations where the individuals were on only 5 minutes. Was that for a purpose because we have a lot of delegations?
That's open forum.
In open forum, yes.
That's not what we're discussing.
Not a delegation, okay. All right.
Delegation
I need to make
to
a
the
distinction
council.
between delegation to council and an open forum delegation.
Open forum is 10 minutes total, maximum of 5 people, I believe. And if there's only 2 people, you get 5 minutes each. If there's 5 people, you get 2 minutes each.
Can there be a reform made to that in the procedures? Because I don't feel that's fair in the open forum process.
And how many people have we had come in the last 3 months?
I'm gonna say none in the last 7 months.
I've had constituents call me as recent as last week and saying, I can't get on the agenda to speak my mind because it's full. And I said, well, maybe you could take it over to open forum. And they said, well, I'm only allowed 5 minutes of the open forum. I'm just wondering if there's a way we can help
Can
people.
they not get their point across in 5 minutes?
Or not according to someone we've had.
Because they should
Yeah.
be able to get their point across in 5 minutes. And then if a councillor wishes to advance that information, then they bring it to the next council with a report.
We'll take this information, thank you.
Peter?
I'd just like to add that it sounds to me like, we want to have people coming to us and be available, and we are available to them. On the other hand, we don't want to waste massive amounts of time. And it strikes me that with respect to the delegations, that we're full up, and if we're full up, then maybe there's more demand than we're allowing. So perhaps we need to allow for, instead of 2, perhaps 3 or 4 delegations, or figure out a way to accommodate our constituents on a delegation side. So that would be my one recommendation to this one, is to maybe try and figure out a way to make ourselves accessible, especially when we consider that, and I know you don't want to hear this number, but 88% of our constituents are seasonal, and they're only here often for 3 or 4 months, and let's try and remember that. So maybe during the times that they're here, we should consider enriching our availability. Thank you.
Well, at the same point, let's look at some best practices to see what others do. And I was thinking of a funny thing here. I was suggesting that you want to make a delegation, but you have to also sit here for 3 hours and watch us, because we had to watch you. But I'm just being facetious on that. But seriously, we do need to have the opportunity for people to speak, because if we don't let them speak, then they're frustrated. I think maybe there needs to be some, a list of what you should do, because obviously if they've got a key issue, the best way to bring it back, phone your counselor. If he's convinced that you've got a key issue, he'll put it on the COW agenda, etc. And I think maybe we need to get that out to the community so they understand the process of how the best way to proceed.
Regarding Member Cooper's suggestion, based on what I've learned from the CEO and Chair Gray, is that if we are going to be moving certain delegations around under staff reports, say people from the district, Seven Sound, maybe if the OPP are coming, if that was something we were discussing as well, that will free up likely at least one, if not both, delegations.
Those aren't presentations.
Yes, the presentation that they would do during the delegation.
That's why we need a little review, really.
So delegations should be individuals coming to petition council or something. But OPP, any of these organizations that are providing information, they should be classified as a presentation to council and be included under certain sections of our agenda, whether they be committee of the whole or council. Council, you're supposed to be making a final decision on something. So if Muskoka Watershed wants to come and make a presentation, we're just accepting their report. Come to Cal. Don't tie up our council day, which is where we're supposed to be doing bylaws and then all the important stuff, and then ratifying what we did at Cal a month earlier.
Larry, I totally agree with what you're saying, but I think this needs a little review between the CAO and the clerk and what other people do, and then we need to get something out to the public to say,
All over the map with other people.
well, okay, well, they can decide the best
Some
practice.
people don't allow any delegations of council, look at all the committees. District, okay, had unlimited number of delegations. And that's why I was there till midnight and later on some of these ridiculous things, because the same person, or the individual stood up, and it was just repeat what the other individual said. And you're going like this, you know, like, come on, and you feel like getting up and just walking out. Because, so, you know, we need some structure to this, and I could see 3 delegations, but 10 minutes each. They should be able to get their point across to us, and then if they have more to say to us, contact their council, contact me directly, contact the staff.
Why not contact us before they do the presentation or the delegation?
They have that option whenever.
It might make it more efficient.
But maybe they want to come and say something to all of council rather than just talking to their individual. But they should be able to get their point across in 10 minutes or less.
So what do you think, Peter? I'll go on with 3.
3 in 10 minutes?
Well, let's leave it to the CAO and the.
Well, this is our decision. This is our decision.
But Larry, you also said that we could free up some of those delegated spots by taking those that should be giving a presentation and pulling them out of there. So in a way, if we go with 3, we're going to have probably 5, or not 5, we're not going to have 5, but we're going to create some more space by the 2 suggestions that have come forward here, and I think we're in pretty good shape.
Great.
3 is fine, I think we suggest we'll free it up. The key for the clerk and I really is the priority planning process, because that's where we get ourselves into more delegations, and no matter how many you set, that's what we get, because we'll get a request for side A, and then we try really hard to then say to side B, they're getting another kick at the cat. It's not fair to leave council with just that one side, so we scoop them in. So that's the key for us, that's the key change. However many delegations you like.
So, is it an issue to, well, this is committee of the whole, we can change anything. So, I think I'm getting a consensus that 3, but limit it to 10 minutes each.
Can I just clarify if that was for council and committee of the whole, or just for council?
Do we have the delegation process in?
We have a deputation with committee of the whole. The same concept, we have the same, with committee of the whole, we also have 2 spots at 15 minutes each. So I think it would be fair to put this same rule across the board.
that's
But
fine.
could we not look at where the time is available? Because I don't care whether I hear it at council or whether I hear it at CAP. So maybe I'd rather, because often the council agenda is a full day, why not add it to I don't see why people should care whether they come to council or CAP.
Now, Laurie, I'm gonna throw this out. We have adoption of the agenda on COW right at the beginning, whereas it's way on in the agenda after delegations and public meeting and consent in our council agenda. But what if we had deputations in COW before adoption of the agenda? Then if one of those deputies, if they are called such, if their item, one of the councillors wish to discuss that later, they add it to the agenda. Otherwise, you gotta wait a month. Okay? So if we alter the order of the agenda.
Because I brought you that report last year, and only my friend Councillor Wayne said that was a good idea, the rest of you were not in support. Because that has always been my issue, that people come, and then they go away and they have no idea what you're going to do with them. So I suggested that to you at least a year ago.
Yeah, well.
And you didn't, I guess.
It's every year to sink in, okay?
Really, but I remember Councilor Wayne was the only one that supported me that day. But it's your procedural bylaw, you can do whatever works for you.
Absolutely.
Well, I was just gonna say, let's try the new thing for a year, but have it as a relook. So that we relook at it 2 years later and say, is this working?
And that's fine. Wait, we had just something that Councilor, he's right in that it doesn't really matter whether people come to council or COW. But again, the piece for the clerk and I is the planning piece, because they never want to come to COW, because COW then doesn't go forward to council, but they're talking about a planning piece that's going to happen at council. So if you fix that one issue, that will solve a lot of these problems for us.
Cynthia, you had your...
No, I was just gonna, well, yes. If we move some of this over to COW, this will increase our date on COW.
So there's some, through your worship, there's already a possibility for two delegations at COW, so it's just adding one more. Potentially, it depends on what the take-up is.
This really happened to get before, so I'm just gonna suggest that, with this year we get, that maybe we're gonna have to consider that we're gonna be here a little longer on our county. Yeah, I have no problem with that, it's confidence our constituents.
We had a 1-hour presentation.
Yeah, we don't schedule a half a day, it's just whatever.
Well, exactly, I'm just saying, if we're switching that around, that's a possibility, and I for one have absolutely no problem with that, it's going to resolve key issues with, bigger people.
So does anyone have an issue with us moving deputations before adoption of the agenda in COW? No. Seeing as you really liked that last year, do you still like it?
That's a two-parter. If we're gonna move it into COW, are we moving 3?
No. We're just talking COW now. Council, 3 deputations
Okay.
in the same order, 10 minutes each.
Right.
We're talking COW agenda right now.
Okay.
Okay, apparently there's 2 15-minute each presently, but it's after we adopt the agenda.
Right.
In other words, we would have to, someone would have to move a motion to rescind what we'd already adopted in the agenda and then re-adopt, that sort of thing. So if we just move it to before adopt the agenda, and then if you decide that, okay, one of the deputations, I'd like to discuss that during COW, you ask for it to be added to the COW agenda before we adopt it, and we put it under new business at the end. That work? Follow me?
Well, my only concern would be, let's not do that with everything, because in a lot of cases, the staff won't have had a chance to do the homework.
Well, we can direct staff to do something.
Yeah, but all I'm saying is, I wouldn't want that to be something that happens all the time, because I think in a lot of cases, staff need to, because otherwise we're sort of making decisions on the fly. I realize it's cow, but we're still making decisions on the fly.
We
We're not
have a
being fair to
resolution
staff.
on the table.
We're not being fair to staff.
We can have a discussion with no resolution. Or we can ask staff to come back with a report in regards to whatever the deputation.
So really, after the deputation, there's two options. It can be referred to staff to continue to research it, or we could then make a resolution and pass it.
And recommend to
Council.
Or you can not add it to the agenda at all, because you just took it as information.
Thank you very much for coming. Have a nice day.
Well, we need to get that on the paper so we can review it. There's a lot there.
So, what we're saying, I think we look for the borough on it, if people call it?
Well, this is just cow. We could
We'll put it on council.
put it on council next time, and if you don't like it, we'll...
Well, I think gives staff a chance to kick the can too on this, as to whether they see any problems. I think you probably identify.
Which is why it's here.
Yeah, exactly.
Good to know.
I'm done speaking.
Okay. That was all I had. Anything else? Do we have a resolution as amended? So, we suggested some amendments, and you've got them all down, I take it. Moved by Councillor Douglas, seconded by Councillor Bianco. Be it resolved that Committee of the Whole recommends that Council adopt bylaw 2016-61 as amended at COW today, which repeals bylaw 2016-22, being the Township of Georgian Bay procedural bylaw. Anything else on that? All those in favor? Carries. I think I'm the only one here that was on 2 terms ago when we went through procedural bylaw. We had copies of procedural bylaws that were, without a lie, over a foot tall, trying to call it. Okay. Thank you. Election changes. Who's addressing that?
The report before you outlines some changes regarding Bill 181, which is the Municipal Elections Modernization Act. Some of the key changes are prohibiting corporate and union contributions to municipal election candidates, regulating third-party advertising, and a shorter nomination period, which is May instead of January, with the end date of July. And the only thing that Committee of the Whole and eventually Council needs to make a decision on regarding this is the option to say yes or no to ranked ballot. I've recommended that we do not do it. I don't know if anyone has had the opportunity to read the attachments, but I've been reading them for 2 months and I still don't understand how we would do this. I do know that, I think it was Michigan that I quoted, it took them 15 days to count their votes in ranked balloting. There is a process where there's some sort of magical calculation where you figure out the minimum amount of seats someone would need to get the position of counselor. Once you get to that far, there could still be other votes remaining you haven't counted yet, but you then have to divide those remaining votes up to the other people who are still there. And I just really want you to say yes to my recommendation that we're not doing this.
From what I've seen of it, it's just a nightmare. Why do we need to do that? It takes long enough now, but hopefully next election, if we put a new process in place, which I'm assuming we will, that we'll have the results PDQ.
Just to concur with the clerk, I think the old method is applied here, and just keep it simple, stupid, and away we go.
I like the new nomination time and then the cutoff. I don't know, it makes it easier. And of course, the cutoff time before was so close to the election time. If anybody came in at the last minute, they really didn't have enough time to go out and do their campaign and that sort of thing. So with the increased time, it should be a lot better. So, the resolution, moved by Councillor Wienko, second by Councillor Douglas, be it resolved that committee of the whole recommends to council to not use ranked balloting in the 2018 municipal election, and via this resolution inform the municipalities within the District of Muskoka and the Ministry of Municipal Affairs. Any further discussion?
I'm sure it's not in here, but I'm just trying to find out, we haven't actually put forward a recommendation in here that relates to the type of voting that we...
That's correct, because I needed to make sure that we were all on the same page before
On this.
moving forward. Yeah.
So then we can still come forward with another recommendation that will say we should use electronic voting, blah, 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 or whatever.
We have until May 1st, 2017 to pass the bylaw, which outlines how we will do the election. And this just gives me a lot more extra time to look into that.
Okay, that's great, thank you.
And seeing as you're the committee of those voters, you're going to come for
Well,
a recommendation.
Yeah, there's some, but I just wanted to make sure there wasn't something inherent in this thing.
Okay. So, anything else on the resolution? Call the question, all those in favor? Carries. No one for open forum? Operations report. Somebody named Brad, I believe. So I think there's some updates since the report was written.
I was the ghostwriter for this, and if that's my email.
Yes, that's fine, I will cover it. And in fact, Brad doesn't really update because he was on vacation last week, but since the writing of this report, the NCA has given us a name of it, so we are planning on out of percent out, so that leaves us some opportunity to look at using space differently. So we just wanted to be council on the state of what we were thinking about. I have mentioned it to the library board. We talked to the historical society about it. I think everybody is largely in agreement that we would like to see the percent house used for some sort of public purpose. It's only some renovations for sure, but we haven't started that in case council says, in a way, we're not in favor of any of this, so we're just giving you a heads up on what this is our thinking. I meant to take a picture of the CEO's office for part of this report because we are so limited in space in this building that Dave has his summer student and her computer perched on the edge of his desk. Then he's got files stacked in boxes stacked to the rooftop. If you've ever been in to
I was in there, yes.
talk to Dave, so if you want the privacy, he's got to boot his summer student out, and she's out and about anyway, so it's not a huge deal, but we just have no space for anything anywhere. We are crammed in every nook and cranny, so this presents an opportunity to get ourselves some space.
Just a question, how often is this room fully booked?
The clerk would probably answer better than I, but when the O&E comes, they take this room and the next room because the adjudicator, or whatever you call them, has to have a retiring space, so it takes a lot of time. And it's often, it is often, yeah.
But is it all the time? All I'm thinking of is possibly we could, if we knew when this space was available, and you could organize some of the other staff to be out, you know, I mean, I'm just thinking, because this room is probably sitting here empty some of the time.
Sorry, I'm not following your suggestion.
I'm saying, you know, rather than the summer student sitting at his desk, at Dave's desk, that's fine, she may have to be there today and yesterday, but could she not be working in here some of the time, the rest of the week? I don't know whether we've got 10% availability or 60% availability.
We'll leave that up to our
That was a small
CEO.
example, and it comes with a computer hardware. I just would like to look at these office, so you understand how tight we are. Keep the classes available, in fact, I won't let Jim in the more next office, because they may be one of the fire hazards.
Right.
Nick wasn't paying attention to that conversation.
I spend most of my life in Dave's office, and, yeah, it needs to be done. My fear is that if you move Dave's office into the percent, so the building department.
No.
Okay, so
No,
did I?
that was just an example of why we need more space.
Okay.
What we're wanting to do is move the library into the reception, renovate the reception, move the library over there, and then renovate the for office space.
That's fine, I was just worried about the protection
Yeah.
of having people walk in and all of a sudden they're in Dave's space right away. No, okay, that makes sense.
Paul?
To give you an update to your update, I just got an email from the chamber, and they'll be starting to build the information kiosk, hopefully starting next week. So I would think the kiosk would be built by the end of the month, so August would be the move date for the set house. That's what the chamber's planning on right now.
Kathy?
Just for your information, after you left the library board meeting, it was discussed.
Yes, I said it dropped it on council, okay, and I apologize for that, but I had given Barb the heads up, and then she updated the library before I had updated council, okay.
Anyway, it was discussed, and I don't think they're in favor. I don't think they understand how you're going to make it nice, you know, and I think it's a fantastic idea to move the library from where it is. Brad took me over there yesterday and showed me all 5 book cabinets, and it's a huge space, and it can be much better used for something else. But I don't know how you want to get through to the board. There's one person on the board, the chairman of the board, is quite vocal about not wanting to go there.
So when I presented it to you, when I presented it to the board, they asked me lots of questions about, you know, does the township have the right to fix them out, and, you know, would there ever come a day, and I said, I could never say never, because I don't speak for council, but my understanding is we're committed to the Fort Severn Library and finding you a space. It may not be the space you're in, because we've got greater needs than just the library that we have to consider. So if council's for this idea, we can certainly work with the library, and they can have some input into the renovation, recognizing that there will be a budget for it, and our budget may not meet their desire. We certainly need to pick up the percent one way or another, and it needs to work on the outside, and we haven't maintained it as well as we should, and having the library there will be the impetus to make council think about the money that we're putting into it. And so the library board will have to work with you to visualize what can be, not what's there right now. But I think it makes sense. It is certainly a nice space in the CSD, but it's a very big space, and you're right, there's a lot of books there. It can be fit into the reception. It just has to be done nicely and safe.
Well, 2 comments. And I guess the library board could come back to us and show us what their lease is with the township, as to whether or not, whether they think they should stay there. I'm just going to facetious on that. But my second question would be, we're really thinking about the longer term planning. I just remember the numbers for operating the set house. It's an old building, it costs a lot of money to operate, is my understanding. Would we be further ahead to take the step and have an ATCO trailer out back that we use for staff? I mean, is this going to solve our problem? And is it going to be an expensive way to solve our problem? And should we be, saying, okay, we're going to get a good trailer? Portables are used in school boards for many, many, many years. So just a question back to Brett.
We haven't considered that option. My understanding is council is committed to the Versat house and maintaining it, so I'm trying to find the best means to make that happen. If there's a different will of the council, I'm not aware of it, so you need to let me know that piece. I'm trying to use the space I have to the best ability.
We had a portable here many years ago before this building.
I appreciate that. I just want to make sure that, we thought of things. I mean,
Peter?
I'm sure Lori's thought of this, but my recommendation is that we almost zero-base our thinking here. In other words, we look at all the space and we say, where's the best spot for everybody? And put them there. And that's the way a business would operate, and I think we can do the same thing. And as I said, I'm sure Lori and Brad have thought of this, but that would be my recommendations. Start at ground zero and map it out and go from there. Thank you.
And Your Worship, I think we've definitely done that. We've spent a lot of time thinking about who should go where. But we have done it under the premise that the Versat house is important to the municipality and needs to be maintained. So that's how we got to the idea of the library should go over there. So if there's any change to that thinking, we definitely need to know and plan differently.
That's great.
Right?
I think it's a great idea moving it into the Versailles. The size limitations aren't such as they are in Montreal or in Honey Harbor, where you have public schools that use this library, where you have, 15 or 20 students coming from the school into the library. We don't have that here in Fort Sutton. We have a very small audience for the library, although it does get used. I don't think we need the square footage that we have in Honey Harbor, Port Severn, or Mount here. I think we can downsize that library a little bit. And in the age and day of electronics and communications via computers, I think probably some downsizing could be done, if needed to be, to get into that building. And I would support the recommendation.
Versat house is big enough to accommodate everything that's over in the community services building, and then some. And knowing the size of the building, and myself, I think it's an ideal place for them to go, because then we free up this space for office space, and they're nice and close to here, and the boss that oversees stuff.
I think I would move to the Versat. Private over there. I wouldn't tell anybody.
We don't want our CEO over there. I'm totally in support of this. I think it's a great idea because the step house, in my opinion, is important to the township. But I think that's an ideal place for the library to go. And I'm pretty sure the staff has made some great considerations, what's the best use of that space or something. So I think it's a great idea.
Okay.
Just briefly, at this point, since you've got the council concurrence that your support, we'll come back with some numbers and some plans.
Okay, so moved by Councilor Douglas, seconded by Councilor Rienko. Be it resolved that the Committee of the Whole accept Operations Report 2016-16 regarding facility resource allocation as information only. Anything else? All those in favor? That carries. There you go, boss.
Thank you. I'm very excited for that.
Well, would be nice.
Yeah.
So the next item of business is Member Cooper, Planning Portfolio Report. And apparently I have 2 resolutions here. Can you give us a high level?
Yeah, I mean, you've received the report, and these were just some areas where the portfolio identified some areas that we'd like to have dealt with or examined, et cetera, and we didn't come to resolutions on everything, but I just would like to stress is from the perspective of zoning bylaws, we have some issues with some various areas where we need we have, let's say, zoning bylaws associated with almost everything, but there's a few areas where we don't have zoning bylaws, and one of them is related to what's called SR 150 and SR 151. Do not have any zoning bylaws. In addition, we have natural state, which is identified as not having anything there, but one wonders if we should have some zoning bylaws related to the natural state area as well. So that's 2 of them. I just recently identified a 3rd area, which is family compounds. There are about 3 family compounds out on Georgian Bay. There may be others elsewhere. I know 3 just in Cottage Machine alone, but there may be other family compounds. And you may say, well, who cares? Well, a family compound is a very large acreage, and we've seen in one of the compounds where buildings have been built without any sort of no zoning bylaws in place that give you proper setbacks and all that kind of thing. So another cottage was built right behind one that was already there, and it's still a very large piece of property. So it didn't make a lot of sense. So I guess what the portfolio discussed was one of the ways to deal with this is our planning department is so heavily tasked at the moment that we might want to consider getting these things dealt with through MHBC. And so that was my sort of resolution. I was suggesting that we deal with some of these outstanding issues. And I know there's some costs associated with it, and if we're concerned about that, I mean, we could put aside the money in the next budget, so be it, but if we do that, then we need to consider putting a holding bylaw in place to avoid some of these properties being developed in the way that they should.
Well, I'm somewhat concerned that these minutes ended up on the agenda and in the public forum. The idea that we had a meeting, none of the staff were available, and the idea that I thought these minutes were going to be at a discussion point with our staff. And so I'm concerned that this is the public, that this is what we're going to do. I haven't even talked to staff, and I think we need to talk to staff about these things. So I'm reluctant to have any resolution today because I don't want to force staff to do anything when they haven't even had the opportunity to discuss it. So I'd like to take this back offline and have the portfolio talk to staff about which ones are viable and which ones maybe require some reports back to council on this. But I think that these issues will require more discussions before we bring anything back to council on this. I'm sorry, but I would never put this on the agenda. Or I don't know, maybe Brian was informed. I was not informed that this was going to be put on the agenda. So I thought this was in confidence and that we would have to talk to staff before we go forward. All these are important items, but we don't have any feedback from staff before we go ahead and get council approval. I'm sorry.
Councilor Edwards?
Well, but Paul, that's what would normally happen here. We would send something back for staff input in a report, and being identified now, we're not coming up with a final, we're just saying, here are some comments, now give it to staff for feedback. I wanted to comment on family compound issue, because certainly in the last term of council, I know I raised the issue that as properties got so valuable, as there's less land available, family compounds are going to be an issue in the coming years. And I think it's very important that we be planning for those. We've got the same issue that so many sleeping cabins have kitchens in them. And I mean, we either enforce it or we bring it into our legislation. I know when I built my sleeping cabin, the first question the plumber asked is, where do you want your kitchen? And I said, no, I don't want a kitchen, but there are some issues like that, and I think family compounds are one that needs our thought going forward.
I've got two resolutions here, but one is asking committee of the whole recommends the council direct staff to engage MHBC to work on the zoning and open space and shore road allowance and all that. The second one is be it resolved, the committee of the whole recommends that council direct staff to work with the planning portfolio to resolve the concerns referred to in the report. I suggest that second one is the route to go at this point in time. I don't have a problem with engaging MHBC, but there may be a budget issue. So we may be September, October sort of thing. So Councilor Kay.
Okay, it's conceivable that some of these things that are on this report, Nick has already identified also on his sheet to at some point look at. So, easy matters, refer to him and say, okay, I'm already dealing with that. So we're not hiring MHBC folks.
That's why I'm suggesting the second resolution, that we send it off and get staff engaged in this, right?
I might suggest that this document that was produced is not a staff document, it's a document in motion. And since this document was created, we have had an additional hire in the planning department, which is moving the planning department forward. And once our busy season is over, there may be time in-house to take care of some of these housekeeping issues. So, and I think it's the intent of Paul and Peter and myself to bring this to Cal to say, this is where we're looking at, but this isn't it. We're trying to come up with ideas how we can move forward with these. And like I say, with additional staff and the work that our CAO and the Human Resources Department are doing, we may be able to do all this in-house. We may not have to go to HPC. So
I think we're all on the same page.
yeah.
I think we are. We have 5 minutes and then we're going to break. If you'd like to finish the agenda so you can leave from the other, I will read the resolution and see if we can't finish up in 5. Moved by Councillor Douglas, second by Councillor Wienko. Be it resolved, the committee of the whole recommends that council direct staff to work with the planning portfolio to resolve the concerns referred to in the report. Call the question. All those in favor? And that carries. Forward to the next report. The next item is Member Edwards, Aboriginal flags.
2-second view on this. I heard that there was an article that John Tory was going to be he's looking at, and I thought had agreed that he was going to fly one or more Aboriginal flags. Given our location, I thought it was important to at least consider it, and I was the right person to bring it forward because I have some Aboriginal blood. So I don't know what the relationship is with our Aboriginal community here, but I think it would be appropriate to at least look at it. I don't know what relation Larry, you have up on your lake where you've got Aboriginal neighbors, but I think, given the Truth and Reconciliation Committee, et cetera, we should at least be thinking about this issue.
I know they're informed of a lot of different things that are going on in our municipality, but they tend not to engage. They have their own government, and certainly Aboriginal Day, any one of the organizations, Six Nations, the Inuit, or the Métis can come and ask us to fly their flag for that week, I suppose, since that's our policy. But rather than having our CAO investigate this, because I know she's swamped with stuff to do at this point, I would much prefer that the originator of the article go off and come back with some sort of a report and maybe engage one of the other councillors, maybe the one to your left, to assist you, just to find out all about that. There's a lot of information on the internet in regards to Aboriginal Day, and certainly we could find the names of the leaders. I'm not even sure who the chief is up at Wausau at this point. There's a lot of political issues.
And just a supplemental, most of the islands on Georgian Bay were purchased from the Department of Indian Affairs, and I know our island was purchased in 1895, so there's quite a history here. I'm more than willing to do that.
So, can I change CAO to Councillor Edwards?
Sure.
You can add Councilor Bochester. You might have a relationship with the Moose Deer Point and Rosalie Island and Wausau, so I would be more than happy to visit during their meetings and do a presentation, ask their feelings on it.
Moved by Councillor Rienko, seconded by Councillor Douglas. Be it resolved that the committee of the whole recommends that Council directs Councillor Edwards and Councillor Bochek to investigate which Aboriginal flags are appropriate to fly at Georgian Bay Township offices and to arrange the permanent installation of same.
Let's change it from arrange to, I don't know whether we want to go down,
Why not just eliminate that end?
yeah, exactly.
Okay.
It may just be a special event flag for the week or two.
I believe Aboriginal Day is the main thing. Any further discussion? All those in favor? That carries. Thank you. One more item. We're going to end up going a little bit over here. And this is to Member K, Public School Graduates. I'll read the resolution. Moved by Councillor Douglas, seconded by Councillor Rienko. Be it resolved that the Committee of the Whole recommends to Council that a policy be put in place in order to standardize the gifting of monies to the grade 8 graduates from the 3 township schools and the actual funding of said fund being included in the annual budget process commencing with the budget deliberations for 2017. Member Kay? Absolutely, this is really official.
Well, as I mentioned yesterday, I was at the graduation for 2 of the schools in Honey Harbor. Our Lady of Mercy, there was 2 valedictorians because we both had the same wonderful grade. So the gift that the township gave to Victoria had to be split 50-50. For Honey Harbor, there was 1 valedictorian, so that person got the whole $100. And that here, I understand, there was 2 valedictorians and they had to split it. I would just like to see it standardized that, you know, all the valedictorians, no so few grads coming out of our system, I'd like to see some kind of a gift given to everyone. It's basically, to me, a gesture of support for the township. These kids love the school. It just helps to, whatever the word is, and I can't think of it.
Good PR.
Good, yes, that works.
Councilor Douglas?
Having attended the graduation of next year, I would agree with him with the I mean, it's pretty admirable to see that our grade 8 graduation, it takes so much time to build together with the activities of the school. It's just something that I find amazing. I mean, there's an interaction that it's just, it's like a family in these schools. And I think it's a really good gesture and a really good show of support to the township. And there's very few graduate teachers. I would be able to support Councilor Payne's motion.
I think we had Councilor Edwards first.
Well, I'd just like to find out whether other communities do this, and I'm just wondering what amount we were thinking about. I guess we consider that at budget time. And rather than money, I would rather that we be giving something. I'll leave it at that. Maybe there's something other than money that we can give that is appropriate.
Councilor Butcher?
I agree wholeheartedly with this. It's a warm and fuzzy feeling that you get from this, and it's only going to do the community good. If we want to come up with an idea of what this $50 gift card is going to be about, it can be about many things. It could be a gift card from the store where you have to buy your uniform for your high school. It could be there could be many different gifts. So I agree with this 100%. It's only going to help.
Paul?
Yeah, and this is why I suggest that we look at the whole grant program and maybe up the grant level of this particular program. I think we need to take a look at all the grant programs, as that was mentioned at a community communication seminar we had a couple weeks ago. So I think we need to look at all the grants. I'm supportive of this, and I like the idea of a gift card or something like that, but maybe not necessarily cash. Maybe you have a little plaque or something like that, or some kind of keepsake or something like that. But anyway, I think we have to look at the whole grant program and slot this in and maybe put $1,000 aside a year or this kind of thing. So
Okay.
I'm in favor.
Cash goes great with kids.
I
Maureen?
I was just gonna say, as a mom to a 13-year-old, cash is king, he doesn't want your plaque. He has to take your money.
Well,
He doesn't
maybe
want
you
your-
can try the
He
wall.
doesn't want your Home Depot card either.
Well, right.
Maybe a lot of council. I look at the deal about that.
You'll find them on the street.
We had instructions to review grant policy as a whole, and graduation is around for another year now, so we can factor that in and put it.
Okay. One more, and then I gotta call a question on the spot.
Have we ever thought of asking the schools whether the kids would like to come down and be here for an hour or two to see how local government works?
I think they'd rather detention.
No, but I think this is very important. I think the schools
We've
would
had mayor for a day before.
Well, yeah, but they don't get to realize that the debate that goes on, what's involved in democracy. I think it would be great, and I think the schools would probably say, yeah.
We can do that, but that's aside from this. Okay, I call the question. All those in favor? Carries, thank you. And I got one more. Moved by Councilor Rianco, second by Councilor Douglas, be it resolved that the committee of the whole is now adjourned at 12:06 p.m. until August 9th, is that the Monday? That's Tuesday, no, it's on the Monday. You won't have quorum on. Call. Until August 8th, 2016 at 1 p.m. roughly.
Funny, this man calls the chair because it depends on what council agenda looks like, what time council will start. We typically bill it immediately following council. And I have no idea what the agenda will look like.
Well, I'm going to put in time to be announced.
obviously on one day.
Okay, time to be announced for call of the chair. All those in favor? There it is.
Moving around,
Yeah,